Okay. On submission, one case I am filing a memo for being spoken to with regard to the policy checkbones. My lord, I have already.
My lordship only expressed that.
I have already seen the judgment is not
Because the order of the High Court was upheld in the
No,
apex
no,
court.
no. I've seen Justice Vinod Chandran's judgment.
Yes, yes, my lord.
In fact, I myself wanted to post it for being spoken to. Then I've gone through the judgment. What is the head note? What is the judgment is not one and the same. And it will not apply to you at all.
But actually, the portion of the High Court where has been discussed, the rights of the third party cannot be diminished, even versus the
But
policy.
still, for your satisfaction, I can have it. I've seen it already. I've seen the judgment. In fact, the other day I was telling Pradeep also that I'll place the judgment for being spoken to. Why should your client be deprived of it? But ultimately, when you go through the judgment, the ratio laid down is not that. Anyway, if you want, we can take.
Once,
Post it on Monday.
Matter of urgency, my lords.
8-9
That's what has happened. I filed an IA before the family court for payment of school fees. Now the trial judge had posted that for orders after hearing the arguments last month. However, on the date of the orders, the trial judge says due to the workload, I'm not able to pass the orders. Now the day after the orders, what had happened? We were liable to pay the school fees. Now after that, after requesting the school gave a date for this month to pay the school fees. That is the day of the orders are posted again on the 18th of September. Now the school gave for the payment of school fees, they gave a date on the 19th. Now we have received a letter from the school stating that this first term examinations are starting from this Monday, the upcoming week. Now they're telling that if we don't pay the school fees before Monday, they won't give the hall ticket.
Are you thinking that the court will pass an order to pay the school fees?
No, not for that, my lords, to at least dispose the IA, my lords, before Monday, at least on Saturday, my lords, because I won't be able to write the examination.
What are you doing till today?
My lords, we have got the instruction from the school, the letter from the school yesterday itself, my lords.
Now, how the matter will be taken up today? What would be the direction to the family court, and when will the order reach?
My lords, if your lordship may at least direct them, we can at least advance the matter on Saturday, my lords, and at least request them to pass an order on Monday, my lords.
Yes.
WP 18317 of 2025, my lord. It was reserved for judgment on 21/7, my lord. And there is no stay in that case, my lord. The trial court is continuing with the proceedings, my lord.
21/7.
Yes, my lord.
We'll have it on Tuesday.
Tuesday.
Concert on Tuesday.
For being spoken to.
That number. Yes.
For being spoken to, this appeal was came to be allowed enhancing compensation. There is some arithmetical mistake. It is not disposed of by this honorable court. It's a coordinate bench. Honorable judge retired. Now roster comes before this honorable court. Therefore, being spoken to, there is some arithmetical mistake.
Yes. Not necessary. Call the list.
List number 2.
Serial number 35, my lord. Serial number 35, my lord. List 1. Time may be granted, my lord. There is a likelihood of settlement. The matter was referred for mediation yesterday, my lord, before the trial court. They have agreed for settlement.
30?
35, my lord.
Inform the other side.
Yes, my lord.
It is submitted that there is a likelihood of settlement. Already the trial court has referred this matter for mediation. When is it coming for mediation?
It was there yesterday, my lord, and again next week it will be there.
Is the matter on 24th?
Yes.
Serial number 32, my lords. For the petitioner, my lords. I informed the other side, my lords. There is a joint memo that has to be filed. If it is on Wednesday, I'll file it, my lords. The parties has to sign the.
Next Thursday, no further adjournments will be granted for filing the joint memo. Yes.
My lords, list number 1, item number 15. That's actually I'm for petitioner. The matter is been referred to Lok Adalat for 13th. We have informed the other side also. There is a likelihood of settlement in this matter.
IA number 103 for earlier here. This also on the same day. It is submitted that the matter is before the
15.
Matter is
First
before
list.
the mediation. Yes.
7.
Matters refer to the mediation, like the earlier case, same day.
List number 2, serial number 2.
Hmm.
Refer to Lok Adalat. List number 2,
That's why it is posted.
yeah.
All the matters will be referred. Yes. All the respondents are served in all the matters.
There are some complaints with office objections.
No, office objections we can see later.
Furnishing of PF in the second
In which
matter.
case?
Second matter.
Second case.
R2, third time.
Furnishing of visitors R2 for third time. In the second matter, a week's time is granted for paying the process, or else the appeal shall stand dismissed against R2. Next.
First matter is for the payment of 30 rupees. Non-compliance of office objections.
No, anyway, let that, huh?
Fixed process fee because of rupees also.
One also. The appellant shall do the needful, or within a week, or else the appeal shall stand dismissed without further reference to court.
None other matter.
Then 5.1, memo is for seeking dispensation of notice to R2. Same, dispense with at the risk of appellant. Refer to Lok Adalat.
In all other matters.
Oh, referred. All matters are referred. Yes, call the list.
Number 1, parted matter, serial number 1.
Madam, my lord instructed me to secure the instructions about the execution. Regarding the recover the other 50% fixed against the owner of the car. I am filed the execution in execution number 17/23, but till today notice is not served on the owner. No recoveries from the owner.
Anyhow, my lord, they have filed execution petition to recovering that 50%. If you are not filed execution petition, my lordship, then my lord, and one more thing is that, my lord, the owner of the vehicle is very seriously contested in rider of the motorcycle is no way responsible for the alleged accident. Initially, my lord, the FIR was lodged against the driver of the car. Subsequently, my lord, that car is not insured with any insurance company. On that basis, my lord, the charge sheet is filed against both the rider and driver.
Rider and driver of the
Car.
rider and drive both. But as far as the third is
Bill
a
and
third
ride.
party,
Yes, my lord, agree, my
PDF
lord.
rider, it's
Yes, my
joint
lord.
and several. Either he can ask from you or ask from the other person. And in those cases, as per the judgment, you can recover that amount. from
Joint
the other
officer, I agree, my lord, joint, but in the fact of case is that, my lord, who is having, my lord, the car is involved is Mercedes Benz car, my lord. He doesn't have policy, my lord. He is having capacity to.
Mercedes Benz owner, you can serve the notice better on him than the claimant.
The lordship could have give a direction, my lord. I will also join with that execution petition.
I'll say, now he can recover the amount from you, and you in turn can recover the amount from them.
Please, my lord, I will join with that execution number 17 of 23. I will also join that, my lordship.
That will
For recovery.
served, owner is served in this.
In execution, owner is not served.
Oh, here.
Yes, they are notice dispensed with
This one, sir.
Then, my lord.
R1, R2 and R4.
But as
To
per the
pass
apex
such an
court,
No, again, you take notice then.
as per the
Because we
apex,
cannot pass order. He is ex parte before the trial court.
He was, my lord. No, my lord, appeared, my lord.
Then, and that too we are going to pass an order.
Appeared, my lord. Driver and owner both have appeared, my lord.
I'll say the order dated so and so is recalled and you will pay the process.
Lord, my submission is as per the apex court judgment, my lord. I can go against one task, any one task, but
If anything.
even I am not,
Please, Mr. Counsel, you can do anything, but it should be principles of natural justice. They should be there before the court. Without hearing them, how can you pass an order? Right, wrong, whatever it is, according to them or you. So we have to recall this order dated 12/6/2023, where you sought for dispensation of notice. And who are those two?
4 and 5, my lord.
4 and 5.
4 and 5 you have to take.
I will take
notice.
only steps against 4, R5, my lord. R5 is the owner. R4 is the driver.
Driver of the car.
Yes. By order dated 12/6/2023, notice to 4 and 5 is dispensed with.
5 is served.
5 is served.
R5 served with DK. Wait, order date also notice to
Notice
R1
served.
and R2.
Sir,
Sir,
It is served.
then, my
That you
lordship.
can pass order.
Regarding enhancement, my lord,
Come to that. Where is the table? Table.
page number 19,
Yes.
18 and 19.
Yes.
My lord, income is considered by the tribunal 20% and assessed disability 22%, my lord.
No, first of all, we'll start with pain and suffering. How many are the injuries?
This,
Femur fracture.
this case of femur fracture.
One,
Please.
40,000. Next. How many days was in hospital?
He was in 10 days as Kasturba Hospital, Manipal.
Already
Food
15,000 is
nourishment and
awarded.
attendance, 15,000 is awarded, mas. And
So
conveyance,
nothing is required. Then loss of income during laid up period.
4,587 is awarded.
Why?
The calculated period, how many days he has inpatient, that basis, my lord, is granted.
So which year is this accident?
2018.
The income rightly considered, my lord, 12,500.
Because
12,500 is considered, my lord.
So we'll take 12,500 into 3.
Pain and suffering is 30,000 is awarded.
Right, 40 my lord.
My lord, as per the evidence of the doctor,
1
Yes.
minute. 1 minute. 37,500. Medical expenses as it is.
as it is.
2,940. Again, conveyance charges are awarded. Is 21,450. So now we have to go on the loss of future earning capacity.
Yes.
Why it should be, why there should be.
My lords, income is, notional income is considered. The tribunal taken 22% disability, my lords. So I
22% to the body.
all body.
What is the?
38%.
38% to the limb, my lord, it is very much on higher side.
Tribunal is considered 22%. My lords, I am not requesting for enhancement of disability. So I requesting for consider the future prospectus of the injured, my lords.
No,
This
my lord,
is
it-
more than 20%.
All, 38% limbed of the disability is not even 10% of the whole body disability. Where is the question of future prospects?
Tribunal is already taken considering the evidence and record 22%.
That's why now I feel that it is already, why should the court take that much?
And my lord,
38% and which part of it is?
humor fracture.
Femur fracture, my
Case
lord.
of
Usually,
femur
my lord,
fracture.
15% to the whole body, lordship is, it's considering more than 15%, lord, in femur, it cannot be, my lord.
Yes, we'll take it as it is.
And my lord, the doctor has said, my lord, PW2, he requests more than 40 to 50,000 rupees towards future medical expenses.
They were incurred, my lord, 2,940 rupees medical expense.
My lord,
No,
say,
sir,
I
they
They
further
have
submit
produced,
that
they
the
have produced, my
petitioner
lord, medical
have
expenses
to
of 2,000.
undergone one more surgery.
Surgery is required, it has been opined by the doctor, my lord.
No, not one more. Medical expenses, if he has undergone surgery, why it is 2,940?
My lord, say Kasturba Hospital, Manipal, my lord, it is charitable hospital,
Oh.
charitable hospital.
Hmm.
And has to undergone one more surgery for removal of
The
implant.
doctor,
40 to 50,000 is stated. No cross examination on this point.
will grant 20,000 future medical expenses.
Because, my lord, the conveyance charges is,
It is granted, that's why I'm not able to
My lord.
understand. What is the evidence for that? 221,450 bills or receipts are filed.
no, my lord, that is conveyance charges, my lord. Conveyance charges, they have
I
awarded
think you
21,000.
better not ask for enhancement.
Lord, in this case, petitioner sustained grievous injuries in accident. hence threatened
You were in
petition.
hospital for 10 days.
10 days.
Court already grants
30,000
15,000.
to 10,000
What is
towards
the
loss of
special
earnings,
head of
15,000 towards
transportation?
nourishment.
It is along with all that. Whatever, no, if the court has to consider this conveyance, what basis it is granted, this
Oh.
21,000 that is compensated in pain and
7 days
suffering.
he spent 4,587 towards the, sorry, loss of income.
Laid up, that's that laid up.
Plus, exhibit P 10 to 12 is the traveling bills, my lord.
That's
10
what
to
I'm
12.
asking.
10 to 12, exhibit 10 to 12 are the traveling bills. Considering those bills, even but tribunal not discussed about the traveling bills, my lord, but is awarded 10 to 12. So Manipal to Davangere, my
Actually,
lord.
what is the amount that is not forthcoming, my lord? Kindly see internal page 10 of the judgment.
Court is too liberal. But still,
I am produced the document, but no discussion, proper discussion is made. Exhibit P 10 to 12 all the traveling expenses bills. Plus, Danagere has to,
Exhibit P 10 to 12 are bills. For granting amount, court has to discuss it. What are those bills? Why?
not discussed.
TCR is there. Take out that P 10 to
10
12
to 12 mallards is 5,650 one bill
to him.
and 5,450 one bill.
The tours and travels agencies, if they have produced.
But because mallards, the Davangere has to travel from Davangere to Manipal mallards, Kastubra Hospital in Udupi district.
Nothing has been mentioned.
Hmm? I think we better not go into that enhancement aspect.
Overall compensation, my lordship may see.
Yes, Mr. Sheshar. We will leave that enhancement. Please come.
Loss of income during treatment is very large.
Then, as it is, we will not enhance except pain and suffering 10,000 will grant, and future medical expenses we will not grant. Already conveyance is granted to you in this manner. So loss of income during the later period at into 37,500.
And what is deducted to 50% malad negligence, composite negligence fixed towards 50%. That has
My
to.
lordship has already expressed that. Jointly, sir. I had to join with that execution petition.
Yes. It's coming to 6,87,890 against 6,44,977. Please come. Agreed with award passed in MVC number 678 of 2019 dated 8th November 2022. The claimant is before this court seeking enhancement of the compensation. Also questioning the apportionment of liability on the owner of the car as well as on the insurance company. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant. It is a case of the claimant that on 29/9/2018 at about 4:30 p.m. he was going on his motorcycle of the relative as a pillion rider. At that time, the rider of the motorcycle rode the same in a high speed and dashed the car going towards the joint road in a rash and negligent manner. Due to that, the claimant and his relative, who was a rider, fell on the road and sustained grievous injuries. The tribunal on the aspect of liability has held that admittedly the owner, admittedly respondent number 2 and 3 are the owner and insurer of the motorbike, and the respondent number 4 is the driver of the car, and respondent number 5 is the owner of the car. It's an admitted fact that the car was not insured at the time of accident. By applying the principles of master and servant, the case against the driver, the rider and of the bike and the driver of the car is liable to be dismissed. Then the respondent number 2 is the owner of the bike. Respondent number 3 is the insurer of the motorcycle. And respondent number 5 is the owner of the car. Hence, both the owner of the bike, car, and the insurer of the bike and the car are jointly, insurer of the bike and owner are jointly and severally liable to pay the compensation. But when it comes to
Para 30 mil.
when it comes to para 30, the court observes that neither the owner of the bike nor the owner of the car have challenged the charge sheet. And as per the charge sheet, due to rash and negligent driving of the motorcycle rider and car driver, the accident has occurred. As such, the court deems it the respondent number 3 and respondent number 5 are liable to pay compensation awarded to the claimant in equal ratio of 50% and accordingly answer the issue. Learned counsel appearing for the next para. Learned counsel appearing for the appellant claimant submits that when the court had already given a finding that they're jointly and severally liable to pay the compensation. Again, in the next paragraph, stating that they have to pay 50% compensation each is not a correct finding. It is submitted that when there are joint tortfeasors, it is for the claimant to recover the amount, and court cannot fix such a liability of 50% and 50%. It is submitted that the award passed by the court as far as this issue is concerned needs to be interfered by this court. Then when it comes to the compensation, the Land Council submits that the claimant had sustained a fracture of the femur. The court had considered, the court had granted only 30,000 under the head of pain and suffering. It is submitted that for the loss of income during the later period, only an amount of rupees 4,587 is awarded. It is submitted that on all the counts, the amount that is awarded by the tribunal is on the lower side and needs to be enhanced. Next para. Learned counsel appearing for the respondent insurance company submits that the court had rightly granted the compensation. In fact, the compensation that is awarded by the court on all the counts is on the higher side and it requires no interference. Next, learned counsel further submits that already the execution petition is filed by the appellant against the owner of the car. In those circumstances, the order that is passed by the tribunal holds court and the insurance company will pay their 50% of the compensation. Next part. Having heard the counsels on either side, peruse the material on record. First, coming to the aspect of liability, there is no dispute about the fact that both because of the rash and negligent driving of the driver of the car and of the rider of the motorcycle, the accident has taken place and the court had fixed the liability. The charge sheet is filed on both the owner of the car and as well as the rider of the motorcycle, driver of the car and the rider of the motorcycle. In those circumstances, both of them are the joint tortfeasors. In those circumstances, it is the claimant. A claimant can sue them jointly, or it is for the claimant to recover the amount. When 50% liability is fixed on each of them, in case the insurance, as he wants to proceed against the insurance company shall pay the compensation, and the remaining the 50% of can be recovered from the owner of the car. Already the execution proceedings are initiated before the executing court, and the insurance company can also join as a party to those execution proceedings. Then coming to the aspect of compensation. Considering the previous injury, one grievous injury, this court is granting an amount of rupees 40,000 under the head of loss of future earning capacity, loss of amenities, loss of amenities, food, nourishment, attendant charges, medical expenses, conveyance charges. This court do not find any reasons to interfere. Then coming to the loss of income during the later period, considering the fact that this accident had taken place in the year 2017.
18.
18, taking the notional income at 12,500 for 3 months. This court is granting an amount of rupees 37,500. In the light of the law laid down in Mekala versus so towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 6,97,890. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 6,44,977 to 6,97,890. Next point, number 2. The claimant can recover the amount from the insurance company, can recover the 100 for the entire amount from the insurance company. No, not recover. The insurance company shall pay the entire compensation, and they can also join the pending execution and recover the 50% of the amount from the owner of the car. Accordingly, this is all other conditions will be there. Take the order and write. Yes. No. KSRTC is there. It is being. After that it will come. Again it will come to the court. Then it is. Yes. Next.
Cell number 2,
Respondent
Pasha.
I am for petitioner. Senior is arguing another court hall, my lords. Kindly it may pass on.
on maintenance, my lord, and custody of the children.
Do that. What are these 2 writ petitions?
My lord, one is, my lord, custody of the children has been challenged.
Ask him to come in 10 minutes
Yes, he'll come. It is arguing the matter. Yes.
and immediately call the matter once he comes. We'll decide it today itself. Yes, next.
Cell number for dismissal matter, cell number 3. Rupesh Abi,
Do that.
appellant, Manjula.
This is matter, no representation on behalf of both the parties. This is matter, what is the date? Next 10th. 11th. Yes, 4.
Cell number 4. Shankara Gowda.
Petition, my lord.
Respondents.
Where is the impugned order?
Page number 85.
80?
Page number 85.
Operative portion?
Page number 89, my lord. The reasoning portion, page number 10, page number 91, para 10 level.
Husband is directed to pay monthly interim maintenance of 20,000. One-time litigation expenses of however, 1 month time is given to the respondent husband to pay arrears of maintenance. He shall pay future interim maintenance. What is the income of the husband?
My lord, the petitioner being the agriculturist and also working as a coolie, my lord, but is without looking to the real facts of the case and also materials.
Not file your statement of assets and liabilities.
Yeah, file the detailed written statement of objection to the main petition.
Not statement of objections, sir. Assets and liabilities.
Yeah,
Yeah, filed.
File,
Yeah,
my
filed.
lord.
But then let us see the discussion, come to the reasoning part.
para 12, my lord. Page number 92, para 12.
Please read.
Please, my lord. The fact that the petitioner number 1 and the respondent are legally wedded wife, and husband and petitioner number 2 is their son, is not in dispute. As on the date of this petition, petitioners and respondent have been residing separately. The allegations of the respondent that the petitioner is leading adulterous life is subject matter of trial. Thus, when the relationship between the parties to the lease is not in dispute, obviously it is duty of the respondent to maintain the petitioners. At this juncture, the applicant petitioner has made out prima facie their entitlement for monthly maintenance pendent rete. At this
How
juncture,
can this kind of appreciation be done by the court? It's wrong.
the 10 years kid is there. The 10 years child
But
now
that
is
is
studying.
true. That is true. But financial capacity of the party who is paying is also
The
important.
capacity of the parties to be considered at the time of granting the
Just
maintenance.
like there's some judgment is considered in spite of the guidelines issued by the apex court. Who is this? Which is this court? Ravindra Jadiyappa.
But I have stated about the income of the petitioner at page number 69, my lord. At the time of filing assets and liabilities, is a cab driver. And apart from that, my lord, he is earning 24,000 from the cow milk. And apart from that, my lord,
when will he drive the car?
the several
and-
agricultural properties are also there in his name. I have stated at para 4, serial number 6.
Let us see his statement of assets and liabilities.
He stated that he is a coolie and earning rupees 10,000 per
But
month.
whatever you say, what is the evidence?
I have stated, I produced the RTCs in respect of the agricultural properties.
How much land he is having?
Totally, my lord, 9 properties.
What is the income generated out of that?
Madam, all our properties situated at Devanhalli, my lord, just 20 kilometers from here.
Now, when you are having the properties, why did you not state in your statement of assets and liabilities? There is a column for that.
Lordship, the property is not exclusive right of ownership of the petitioner, my lord.
That also there is a
joint
column.
family properties,
For joint family, there is no column in that.
but they are narrating the the other's property as a my property. That is the
So I
false, my lord.
said, there is no column to mention the joint family properties, which you are a joint owner.
The property stands in the name of my father and also my mother, my lord.
Could be.
We have 5 children along with my brothers and sisters. There is no exclusive right of ownership which belongs to me. Therefore, they are claiming the maintenance of rupees permanent alimony of 1 crore and also maintenance rupees 50,000 per month. It is too exorbitant, my lord. And
What is reasonable?
Lordship,
What is reasonable?
my lordship, I am ready and willing to take back up my child and wife without any conditions, my lord. But she never
They are not.
interested to join with us.
So the
my lord.
harassment given by the petitioner and the
Therefore,
family members, she is residing
It is
separately.
like this.
Subsequent to death of my father,
It is, if you want, I can set aside this order and demand the matter, or else we can grant 10,000.
Now the 10 year, for the last 3 months, my lord, they have not paid anything.
3 months.
For the last 3 years.
There is a stay in this.
No, initially the stay was granted subject to deposit.
Filed
Initially stay was granted subject to deposit. They are not deposited the amount. So
That's true.
interim order is automatically vacated. Now we have filed execution petition for recovery of the amount. In the said execution
Court,
petition,
if this court fixes a maintenance, the court will be doing the same mistake as it is done by the trial court. So if it is 10,000, it is a reasonable amount.
some reasonable amount can be granted.
10,000.
Child is
If you want more than that,
no. 10,000 the child is okay, my lord. But with respect to the wife, petition number 1 is concerned.
child, I'm saying entire. If somebody says I'm a daily wage laborer, how can the court grant any other amount?
Though the child is studying in 4th standard.
That's what I'm saying.
Then
Either
she-
if you want this court to pass order, I'll make it 10, or else if you want to take a chance, I'll set aside this order and remand it for fresh consideration.
Meantime, kindly direct them to deposit at least
He
10,000
has to
per.
deposit. Who has filed this is a criminal miscellaneous?
Criminal-
MC is filed.
No.
No MC is filed. Criminal miscellaneous rules from 2022 without any other proceedings. Parties.
Only 125 proceedings is pending. This is the only pending.
No restitution, no
No
divorce.
restriction, no divorce.
Neither the wife will join nor she will give him the.
She is residing with her parents' house.
she's not residing with
I
parents.
know,
She's
just-
residing
can I make-
separately and
no
also
objection
working
for
as
remaining the
a
matter.
executive
Let them,
prestigious.
let them deposit the amount of 10,000 per month for 3 years from the date of filing the application is concerned, my lord. Let them deposit the amount.
My lord,
For
after
reconsideration, I have no-
subsequent to death of my father, I have aged my parents, and so after death of my father, I am take care of my mother also and residing with my parents in native place, my lord. How can I pay the monthly maintenance
stated.
rupees of 10,000 to the petitioner, respondent number 1, Your Honor?
Why you
I
are
am
not?
totally,
He himself
Why you
stated,
have not filed your execution till now?
she is not interested because the harassment given by them,
there is no harassment, my lord. Kindly peruse the page number
That?
17,
the
my lord.
harassment given by the
Not,
the
no,
in-laws.
no harassment, my lord. Without intimation to the parents of. She left
I
out the.
said, why have you not filed your execution?
The execution is already filed. Arrest warrant is issued.
Huh?
Arrest warrant issued is against the respondent.
Then nothing else can be done. That's the only thing. Well, I'll reduce the maintenance from 20 to 10. Please come.
10,000 is very vegan.
Then I'll remand. Only
I have no objection for remand, but let them deposit the 3 years.
No, okay, I'll pass an
With
order.
at the rate of 10,000 per month.
No, I'll pass an order directing them to pay.
Considering the education of the child, my lord.
You're not
At least let them
understanding what the
deposit.
court is saying. Yes, I'll pass an order. Already there is an order passed. What happened to that? So what purpose would be served? Ultimately, it has to be executed. Your execution is pending from the last 3 years.
No, the execution petition just filed 2 months
Then
back.
arrest for the warrants are issued.
Yes, please.
I'll remand this matter. Agreed with the orders passed in I number 2 in criminal miscellaneous number 888 of 2022, whereby the court had granted 20,000 maintenance and 10,000 legal expenses. The husband is before this court. Parties are referred to as wife and husband for the sake of convenience. The wife had filed the criminal miscellaneous.
I did take up the matter on Monday. I will get the instructions from my client. If she is ready to for 10,000, my lord, file an effort. Kindly after Monday, my lord.
Yes, list the matter Monday. Anita.
Instead of
Monday.
remanding and further inquiry, I will file an effort.
Nothing much is going to happen because you can't prove all that. Yes.
For 5, for orders matters, Vijay Nayak.
Yeah, for respondent.
Value of the appeal exceeds 15 lakhs. Therefore, my lord, matter may be placed before the honorable division.
A memo is filed stating that.
I will submit
Valuation of the appeal is above 15 lakhs, and the matter may be posted before the division bench. Is considering the same. Registry is directed to list this matter before the division bench. Next two.
Cell number 6. Mohan Kumar T. For furnishing of the.
Appeal for the appellant, my lord. Kindly grant 2 weeks, my lord. I will take steps.
Why 2 weeks? Take another 10 weeks. 22 matter. You the
Next week I will take 2 weeks time. Because in fact, my lord, I have not moved my lord, the appeal. This court all moved, it's mentioned, but I have not moved it, but wrongly it has come. I will ascertain the correct address, my lord, a week's time again.
A week's time is granted for taking steps, or else the appeal shall stand dismissed without further reference to the court. Yes.
Cell number
7.
7.
Memo is filed seeking dispensation of notice to R2. Dispense with at the risk of appellant. Admit post for final hearing. Call for the TCR.
Cell number 8.
Serial number 7, Your Honor.
Huh?
Serial number 7.
7 night says. Dispense the
Yes,
admit
next,
final
8.
hearing. Cell number 8. HV Manjunatha.
Huh?
Sir, use the mic, sir.
8. HV Manjunath, 8.
They have filed cross appeal, my lord.
Cell number 8. Class
If the cross appeal is not served on.
Respond
That
number
will be
3.
37 of 23. It is
Papers
listed.
are not served on you.
6073 at night.
What is
6073 is also listed, sir. MFA.
Yes, sir.
papers are not served?
They are not served the papers on me.
You appear for in MFA crop
MFA number 6073 of 19.
for the respondent.
Cross appeal has been filed by the insurance company. They have not served the copy.
Yes, insurance company is directed to serve the copy on the car.
I'm not for insurance company, my lord. I am
Whoever it is,
2148.
on the insurance, on the land counts for the claimant, list this matter
Sir, connected.
in the month of November. Yes, next.
Cell number
9.
9. Cell number 9. PK Mohan,
Honor, ಇದರಲ್ಲಿ already lower court ಲೋಕ ಅದಾಲತಲ್ಲಿ matter settled.
Matter settled.
I have reported to the before the court.
Well, our amount, they have not paid the arrears.
A memo is filed stating that
In the
Lok Adalat dated 11/7/2024.
Lord, this is in respect of MFA petition. I will verify and submit.
not in MFA, sir.
So anyhow,
All-
Mr. Counsel, it is his petition. It is his
Please,
petition, so doesn't matter.
Please.
The matter is settled as per the Lok Adalat award dated 11/7/2024. Hence, as the dispute between the parties is settled and nothing survives for consultation, hence nothing survives for consultation in this petition. Accordingly, the same is dismissed as infectious in view of the settlement between the parties. No, it is settled according to.
In the last para.
Yes, yes, next.
serial number 10,
Respondent claimant, case of death malad.
Where is the counsel for the insurance company?
Kindly pass on.
No passover today.
AN Krishna Swami, T Vijay Kumar,
Case of death malad. The claimants are the parents of deceased man. Enhancement or insurance company also. Company also prepared appeal. Only enhancement I can assist.
Company's appeal is also there.
Pain recovery order has to be made, my lord.
If they are there, they are here, we could have done it. Today passover is not possible. This is matter on 8th or 8th.
Eighth, please.
No representation for the insurance company. Post insurance company's appeal for dismissal on that day.
Please.
That is MFA 501 of 2021. Yes, 11.
serial number 11, S Nirmala,
And for the appellant in 1042 and 587.
My lords, in one of the case, in KSRTC appeal, I have filed for releasing the amount of 50%. In connected matter, I already bought a record, LR's record on record. In another connected matter of 587 of 2021, 870 of 2021, I have filed an application for bringing LRs of the deceased. So I request the honorable court to release the one of the cases, release the release the amount. In other
You are on
permit.
liability.
No, LRs have to bring in, no, madam. That is the application pending before now. In 587.
Then only it can be considered.
LRs already, how they have to amend.
Hello.
Amend the cost title.
I'll do it. In one of the case, now he has to get it amended, madam. Our application has to be allowed. It is listed only
And that
today.
case,
Case. 11.1, I number 1 of 25 is filed. To bring the LRs of the deceased respondent on record. Then counsel submits, so-and-so submits, he is appearing for he has instructions to, he has already, what is it for LRs of deceased respondent? Without it, that is not ordered
no, my lord, in my appeal, I have already amended and filed custody.
as it is submitted that Mr. Satish Chandra,
I have to amend, madam.
Satish Chandra R is appearing for these LRs in the other MFA and in this also he takes notice. Accordingly, I number 1 of 25 is ordered and so or brought on record as LRs of the deceased, and the appellant shall file the amended cost title within a week from today. Yes, in both the cases.
Please.
In this also, in MFA 1042 also within 1 week, we'll hear on that day.
Please,
I'll do
case
it.
at essay.
Please, they will
I did it, they have to do
No,
it.
no, I will do it with.
do it in a week.
My lord, I may,
And in 11.2, you have to file.
I have filed a LR's
Both their
application.
appeals, I have to
Day
do
number 1
the,
of 25. That is your appeal. Yes. So-and-so is ordered. The LRs are brought on record as so-and-so. Amended cost title to be filed within a week. Yes.
much.
serial number 12,
Next week when it comes, we will see.
Please, madam.
12, Nagesham,
Please, madam.
My lord, respondent number 2, my lord, insurance company served.
Who is United India Insurance Company?
Yes.
Who is here? Pradeep, you don't appear, United India.
United.
Who else? Shivanagoda appears?
Shivana.
Shivanagoda is directed to take notice on behalf of the insurance company and learn counsel for the applicant should serve the copy of the appeal memo on the counsel. This is matter on 11th?
Oh.
Death case, my lord.
Huh?
Death case.
11th.
Please.
Cell number 13, Pradeep B.
Yes, Pradeep.
Appearing for the appellant.
You're on what ground?
Quantum.
Quantum.
It's a case of injury, my lord.
Will have heard the learned counsel for the appellant, no representation for the respondent. This is matter as part heard on 11th. Yes, 14.
Cell number 14, Harish NR.
I filed this application seeking recall the order dated 21/7/2025.
What is that order of 21?
On that day, this honorable court was pleased to dismiss the appeal for non-prosecution.
Then why should we recall?
Now I entered NOC Wakalat.
RPS, so you filing the NOC Wakalat is not a ground for recalling the order.
What happened?
Please come to the, I'm very clear on these kind of matters. The court is not at all going to be liberal. Just like that, it cannot be taken, the RPFC of the year 2020. Till now, no steps are taken for issuance of notice to the respondent. When the matter was listed on 8/7/2025, there was no representation and no notice is served on the respondent. The matter was directed to be listed under the caption for dismissal today. Today also there is no representation. Hence, the appeal is dismissed. Where is that IA? Where is that
application I filed on
what are the reasons stated?
29/7/2025.
Yes, read.
Please, para number 2. I state that above case was posted before this honorable court on 18/7/2025 for orders regarding taking steps regarding service of notice on respondent. On the said date of hearing, this honorable court was pleased to direct me to post the
No. What is this? What your client is doing from 2020 without even paying the process, without even serving the notice? What is he doing from 2020?
My lord, is avoiding service of now, my lord.
No, not avoiding, not even months. Let's see, when was the process paid?
Please, well, one submission is now he is representing in the MFA number 7368 of 2020.
Don't go into the other issues. First of all, you have to cross the first hurdle.
Please,
to go to that. You have to convince the court on that.
Please, my lord.
This matter came up on 8/3/2021. None appears. 5/4/2024. None appears. 29/5/2024. None appears. 26/7/2024. Finally, 2 weeks is granted. Time is granted to do the needful. You will not do the needful. Again, the matter is listed for orders. There is no representation on behalf of the parties. RPSC of the years. No notice is served the respondent. Is this matter? So I do not see any reasons
My
to
only
pass any
request,
other order.
my only request is, my lord, now husband is representing in MFA number 7368. After lapse of in that case also, my lord, if I'm permitted, my lord, I have served and summons, my lord, within 2 days.
First of all, there should be a reason. Why you are not doing anything right from 2020 till 2025?
My instruction is, my lord, she has handed over the file to the previous advocate.
When?
He has initially filed appeal petition through his advocate. Now, my lord, due to default of his advocate, he could not. That is the reason.
No, it is stated that no defaulter. It is not intentional. Something has happened, and this is happening from 2020. For 5 years, it is happening, and so many times the matter will come up. You will not pay the process. You will not do anything. And you want now the matter to be recalled.
No, my
I'm
lord.
sorry.
Only
Please
one
come.
day, my lord. Today itself, I will do the needful. But what
Please
happened?
come.
Claim petition, my lord, maintenance petition came to be dismissed, my
Let
lord.
it be
Therefore,
dismissed. You will
one day, my
survive
lord,
in
today
your
itself, I will report the needful
years
decision.
without a maintenance. Please
Today
survive
itself, I
that
will
way.
report the needful damages.
RPFC is
Connected
filed.
matter is pending more. Therefore, I am
Dismissal
requesting.
of the
Connected MFA is pending.
petition seeking maintenance to the wife. The order that is passed the order is passed on. Miscellaneous is filed in the year 2019, and the order came to be passed on
Today itself, I will do
6/12/2019.
serve the answers to
And the appeal is filed, the RPFC is filed in the year 2020. But it has come up before the court for the first time on 8/3/2021. Even on the first day, there was no representation. In the entire docket proceedings, every time whenever the matter is listed, there is no representation. Only though there is even when there is no representation on on 26/7/2024, a 2 weeks time is granted to do the needful. Thereafter, as there was no representation, posted for dismissal. Again, after giving an opportunity, it is dismissed for non-prosecution. Now the learned counsel, IA is filed to recall the order where this petition is dismissed for default. The reasons that are stated is the client has taken no objection. Earlier advocate is not representing. When the wife had filed a maintenance petition in the year 2017, and in the year 2019, when it is dismissed, that is almost about 6 years back. If the party has any interest or any requirement for the maintenance, she wouldn't have kept quiet for these long years without even pursuing the matter. These kind of applications without a probable reason, the courts cannot entertain. Already court has shown, has given enough time to the party. In these circumstances, this court do not find any reason to recall the order dated 21st July 2025. Accordingly, IA number so-and-so filed for recalling the order dated so-and-so is dismissed.
She also filed a complaint before the Bar Council against immediate submission.
Let it be decided, we will see. Yes.
Cell number 15 adjourned.
Yes.
16. Akasha Rao for petitioner. Aminullah NK.
Appear for the petition. The respondent husband's petition for grant of interim maintenance which has been challenged. The impugned order.
Where is the order page number?
Impugned order is at page number 74. 174.
170.
174. But I'm agreed with two facts, man. First is, Lord, there is a substantial amount which has been paid by me.
1 minute. Let me just see what is the order.
Please.
How much is granted?
35,000 per month.
35,000 to both wife and
Child.
One child. What is your income?
My income is 1,85,000.
1,85,000.
I have two dependents who are my parents or aged.
So in every
And
case,
moreover, my loans are running more than 1,30,000 per month. For your lordship's
loans you have taken.
house loan, my lord, there's a joint property which I and my father own, and out of which there's a 38 lakhs outstanding loan is there on that property, my lord, which is for which I am paying an EMI of rupees 90,000 and odd. And apart from this, I have few medical loans, my lord, where I am treating my father and my mother for their medical expenses. Those loans are pending, my lord. Now, my lord, why I am agreed with this order is that, my lord, whatever I have paid, substantial amount. I mean, even if it's considered, 11,55,000 will be the total amount due, my lord. Out of which more than about 6 lakhs is already paid. I think even my learned friend acknowledges the same of it.
No, we are not on the interim, whether you're paid or not paid, that we are not looking at.
Please.
We are looking at whether this order is right or wrong.
Please, that's one part. First part, my lord, whatever I've paid is not
Let it be
considered in
decided
this.
by the trial court. Let it file a memo, calculation, everything will be
That's
decided.
that's first part, my lord. Second, my lord, kindly request you to go to page number 175, my lord.
Yes.
Page number 175, Lord, the first paragraph. After remanding the matter, the petitioner has furnished a fresh affidavit of assets and liabilities with bank statement commencing from July 2022 to February 2025. Lord, the date of the IA is July 2022, my lord. Now, when the date of the IA is July 2022, as per Rajneesh versus Neha, he has to file 3 years bank statement prior to the date of IA, wherein she has filed it from July 2022 to 2025. Which I am agreed with.
Where is your case that she's earning?
But she's not earning. She's a BCom graduate.
Then?
Oh, my lord. It's a whole short point, my lord.
And that is, it's a purely technical issue. Is it your case that the wife is earning and still she is seeking maintenance from you? Where did you say so?
No, I'm not saying.
So how does it come in the way?
I'm not saying for a moment, my
But,
lord.
no, on this, why should the order be set aside?
What I'm agreed with, my lord, there's a perjury application which I have filed before the trial court. There are two types of perjuries which has been committed. One, my lord, with respect to pendency of the old cases. There were few cases which were pending before me and the respondent wife. Those cases were not disclosed before the honorable trial court when she filed her assets and liabilities. That's the first ground, my lord. And with respect to the address what she is given before the trial court for filing the petition, that also comes to be false. And I find out, and she also files her objections to that perjury application, wherein she admits, yes, I'm not residing in that address.
That will be decided.
But my perjury application, my lord, is still not passed. There's no order passed till now, my lord.
Please restrict your arguments to this idea.
But
How is it right, wrong? I am not going into any other aspect.
My only
Why
grief,
granting 35,000 is on the higher side, only one.
Yes.
Only argument on that.
my only grievance is, my lord, now, my lord, the loans run more than 1,30,000.
Why did you take?
Housing loan is there, which is a joint property. It's not my property.
So you're enjoying it.
No, my lord. My
Joint
father is
property?
taking the rent of it.
Then why are you paying that much of?
So I'm just
Now-
supporting my father, my lord. Sorry. I'll restrict to this, my lord. Whatever I've paid, more than half of the amount which is pending is already paid. Let that portion be calculated by the trial court and let there be a consideration of it, because
No. We'll not consider anything. 35 is a reasonable amount.
35, I'm not disputing about the quantum of the amount which has been ordered, my lord. My only grievance is when the total amount is 11,55,000 and where I've paid to the money to the tune of.
I said already,
Let me
no,
file a memo
we
for
will confirm this order. As far as the amounts that are paid or not paid, both of you file your respective memos.
Yes,
Court
Your
will look into it.
Yes, Lord.
Let that be considered, my lord. The only grievance is, my lord, when
It will not be considered.
It will consider.
because in the order it's not mentioned explicitly, my lord. That's the whole concern. They've only told pay 35,000 from the date of IA.
Whatever is given, it goes without say. If you have already paid, that will be that amount will be considered
My lord,
and it will be
that
deducted.
amount has been, my lord, in fact recorded in the order sheet.
Yes, please come.
Not considered.
Yes,
The whole concern.
I agree with the orders passed in I number 2 in criminal miscellaneous number 531 of 2022, whereby the court had granted 35,000 as maintenance. The husband is before this maintenance to the wife and the daughter. The husband is before this court. The admitted facts in this case are that the wife is not working. The husband salary is 1,85,000. It's a case of the husband that a substantial amount of 1 lakh is paying towards the EMI, and also he has to take care of his old age parents, and also he's paying the amounts towards the medical insurance, medical expenses of both the parents. It is further submitted that he has paid several amounts, and the court had passed an order wherein the court has observed that it says the respondent is directed to pay arrears of maintenance.
That's it.
What else you want? Arrears means what?
It's pending.
My lord, in fact, I have brought it to the notice of the trial court that I have paid this
It is
amount.
only just for buying some time you have come to this.
No, my lord, I'm still
The
paying.
respondent is directed to pay arrears of maintenance within 3 months from the date of the order.
That's all.
The submission of the land counsel for the petitioner is that he has already paid certain amounts. Now, by virtue of this order, those amounts which were already paid by the petitioner are not at all looked into by the court. And his apprehension is that he may have to pay the entire, the order of the court is without even deducting the amounts that are already paid. He'll be made to pay the entire 35,000. Next parallel, and counsel appearing to the respondent submits that the court, considering the financial capacity of the husband, has rightly granted an amount of rupees 35,000 towards the maintenance, and there are no reasons to interfere. Next para, having heard the counsels on either side, there is a material on record. Considering the income of the husband and looking at his financial capacity, the court had rightly granted an amount of rupees 35,000, and this court and no interference is called for. Then coming to the contention of the land counsel with regard to the amounts paid, the order of the court is very clear. The amount is 35,000 per month. If any amount that is paid by the petitioner will be deducted, and the remaining amount he has to pay as per the
6 lakhs.
as per the order of the court. Both the parties, within 10 days from the date of the order, both the parties shall file their memo of calculation, and basing on that, within 1 month from that date, from the determination about what are the arrears, the amount the petitioner shall pay within 1 month from there on, and shall continue to pay by 10th of every month.
Great.
17, preliminary hearing.
Yes, next.
Kamaleshwara Pujari,
Petitioner.
petitioner.
My lord, the petitioner is the wife.
Connected
Respondent is the husband.
Connected matter.
Huh?
Connected matter.
You appear. Yes.
My lord, the petitioner is the wife.
Hmm.
Respondent is the husband.
Hmm.
Respondent filed divorce petition
Hmm.
under section 13(1) IA of the Hindu Marriage Act.
Come to the impugned order.
Please, my lord. Impugned order is annexure A, my lord.
Memo of withdrawal filed on behalf of the petitioner is allowed on cost of rupees 5,000.
Yes.
What is that memo of withdrawal?
My lord, he conducted the case from 2021 to 25. Thereafter, my lord, he committed a criminal case. Thereafter, he wanted to escape from the clutches of the criminal case. He filed memo before the trial court seeking withdrawal of the petition, which we opposed. And we requested the court.
How can it be? How can a writ petition is maintainable now? No, by virtue of this order, the MC itself is closed. MC is closed, is it not?
But my lord, kindly see, fact of the case, kindly see.
Not facts, sir. What is the order? They wants to withdraw the MC.
Yes.
That is passed. No, there is nothing pending before the court. It is withdrawn, complete. It is not an interlocutory order. It is a final order. If you are aggrieved, you have to file a MFA.
Madam, kindly see the last operative question of the order, madam. Memo of withdrawal filed on behalf of the petitioner is allowed on rupees 5,000 anti. Whether the petition is dismissed or what, there is nothing is mentioned.
It should follow, the court should give a decree. It should say that accordingly the MC number is dismissed. Whatever is the way the court had passed the order, the consequences, everything is closed.
But my application is still pending.
When the MC is closed, why would your application be pending?
Some order has to be passed on that IM. Without considering the IM, my lord, court cannot dispose the matter.
Your remedy is not before this court. What is your case?
27153 WP. Connected matter. Huh? Connected matter. WP 27153.
What is
that? The petitioner is.
I know. What order you are questioning?
So far as that is
You that.
Madam, so far as connected matters is concerned, the learned trial judge has ordered interim maintenance of rupees 10,000.
When the MC itself is permitted to be withdrawn, what remains in this?
This is a separate case. This case is separate case, and that case separate case. This case is filed by the, so far as connected matters is concerned, criminal mispetition is filed by me, wife, for seeking maintenance, wherein my lord, the honorable court has granted interim maintenance of 10,000 per month.
So the first case is arising out of the matrimonial proceedings against the matrimonial case.
Yes.
And this is in a criminal misdemeanor.
Criminal miss. Between the same parties. Between the same parties
maybe
and.
As far as this is concerned, writ petition is not maintainable. Whatever is the remedy available to you, you please pursue. Please come. WP number 17822 of 2025.
My lord, regarding second.
This case I'll pass orders. First of all, I'm passing order in this.
My lord, both the matters are arising out of the same, both may be disposed of common order, my lord.
How can it be? How can it be? I should have the jurisdiction to pass an order.
When
the writ petition is not maintainable, how can I pass an order? Because it is the next writ petition court has jurisdiction, so both will be clubbed and passed an order. It can't be.
My lord, the court has not passed the decree, my lord. Lordship, kindly see. He filed a petition and seeking withdrawal of the petition. It doesn't, now it is mean that the matrimonial relationship is still pending.
Case is not pending.
Yes.
What is
case is not pending.
Please look at the Family Courts Act. What is this order? You call that order. Please look at it. You can't maintain a writ petition. Writ petition is against the interlocutory order. And the main petition should be pending before the family court. MC is already disposed of by this.
Under Article 227 is the discretionary power, constitutional power vested with this honorable court. If any injustice is caused, my lord, this honorable court certainly has power to redo the same. This is not the general provision which I thought. I am invoking the inherent power and constitutional power of this honorable court.
227.
Yes, that's what this honorable court has absolute power to redo the mistake if any. That's what I am requesting this honorable court. Kindly hear my argument, then pass appropriate order.
Yes.
Case is, my lord, kindly say. Fact of the case, my lord, kindly say. The relationship is not disputed.
Yes.
My lord, after marriage, the marriage was taken place on 24
All those facts not necessary. You only argue on the jurisdiction of this court in entertaining this petition about the maintainability, not on the facts.
Maintainability is concerned, I am invoking Article 227
Give Article 227.
Constitution, wherein, my lord, this honorable court has absolute power to redo the mistake committed by the trial
Let's
court.
read Article 227, what it says.
Supervisory power of this honorable court.
So, where there is a right of appeal, there also this court exercising
And
Article
appeal Barudilla,
227.
Lordship kindly say, appeal is not arising because the petition filed by them, they filed the petition after conducting the case for a period of 4 years. That too after committing criminal case. They wanted to withdraw the petition by causing the hard loss to the wife. That's what. Now, my lord, if it is a decree or dismissal order, then I can certainly has appeal. Here there is no order has been passed. He simply allow the petitioner to withdraw the petition by imposing cost of rupees for 5,000. My case is in my lord, cannot see. During the pendency of this case, he tampered my PF account. Then I made a complaint to the jurisdictional police. Police registered a criminal case against him under section 220. My lord, he colluded with this friend, Mr. Soumya, and they tampered my PF account. Then my police filed a FIR as well as finally filed charge sheet against him. Having appraised such criminal case, all of a sudden, he filed a memo before the honorable court seeking withdrawal of the petition. Earlier also, my lord, after my marriage, forceful manner he obtained the consent letter by saying that he is ready to pay 3 lakhs rupees to me. Consequently, I have to give the divorce to him. Based on such understanding, kindly see the consent letter executed between the parties I produced before this honorable court, forcefully sent me out of the house. Then based on the said consent letter, my lord, he filed a divorce petition. He conducted the divorce petition for a period of 4 years. After registration of the criminal case against him, he wanted to withdraw the petition. Because of that reason, my lord, in the earlier stage, I opposed for divorce. After conducting his conduct, I feel that, my lord, it is not possible for me to reside with him. My lord, kindly see the petition, averment, my lord, averment number 8 and 9.
Yes, please come. Agreed with the orders passed in MC number 6155 of 2021. Whereby the court had permitted the petitioner, permitted the husband to withdraw the MC. The same was allowed by order impugned by imposing cost of rupees 5,000. Agreed thereby, the wife is before this court. Land counsel submits that the conduct of the husband is not, the husband is conducting the affairs in this manner, having contested the matter for four years. Now he has sought a petition filed a memo to withdraw, and the court has permitted the husband to withdraw the petition. And the learned counsel also argued on the merits of the matter with regard to the conduct of the husband, how the criminal cases are filed against him and against him. It is submitted that under Article 227 of the Constitution of India, this court has got inherent and extraordinary jurisdiction wherein the court can interfere and pass orders when there is a pure abuse of process of the court. And this court has jurisdiction to entertain a writ petition filed under 227. Next para. And counsel appearing for the respondent submits to the court that considering the petition filed by the husband, as it is his prerogative to pursue the matter or to withdraw the matter, had permitted him to withdraw. Next para. The counsels on either side.
Section 25 application filed by me is pending. That's considered.
it is submitted that section 25 application that is filed is pending. Having heard the counsels on either side, there is a material on record. The writ petitions are filed before this court as under 227 against an interlocutory order that is passed by the family court. This court is having jurisdiction to entertain the writ petitions, and whenever a final order is passed in respect of criminal miscellaneous, the RPFCs are entertained by this court. If it is a final order against that, an appeal lies to the division bench of this court, as per the Family Courts Act.
Liberty may be granted. Liberty may be granted to file appeal.
In this case, by virtue of the order impugned, the MC that is filed by the petitioner, by the husband, is withdrawn. There is nothing pending before the court, and this cannot be treated as an interlocutory order. Once it is not an interlocutory order, this court has no jurisdiction to entertain this writ petition. In view of the same, the writ petition is dismissed, giving liberty to the appellate petitioner to avail the appropriate remedy, if any, within a period of 1 week from today.
1 month, my lord. 1 week is not 1 month may kind of.
Why?
1 month.
Then I'll say subject to the law of limitation.
Certificate copy, my lord, we have to obtain
To
certificate
the
copy. 1 month.
Law of limitation. Yes, next. What about this?
Next is my lord case filed by the respondent.
Madam, for petitioner, kindly pass out the matter 230.
This is matter on 11th of.
My lord, kindly see, interim order passed in the year 2023. Even today also, my lord, he is not paying the interim maintenance.
He's asking for a pass over. It is not possible today. I will take it up on 11th. Yes.
Number 18. Number 18. Santosh View.
Petitioner is the husband before this honorable court. The petitioner is challenging the interim maintenance ordered by the.
How much is granted?
15,000 has been ordered, my lord. 15,000 for the respondent number 1 and 2. 1 is the wife and 2 is the child, my lord.
Both of them 15,000 or 15,000 each?
Both of them 15,000.
What is your income?
My lord, my income is 20,000, my lord. My lord, the factual narration is that, my lord.
Comes with impugned order.
My lord, the impugned order is at page number 17. The operative portion is at page number 33, my lord.
One order that I wanted to remind, and he asked for time before. That order also, take a copy of it and send it to R&S. No, he's sending it. This also is. Yes, page number.
My lord, the operative portion is at page number 33, my lord. Impugned order starts from page number 17, annexure A. My lord, the factual matrix is that, my lord, the petitioner was earlier married to his first wife, who
Have you filed your statement of assets and liabilities?
Yes, my lord. Statement of assets and liabilities have been filed.
Which court is this?
My lord, it is before the principal judge, Family Court, Bangalore, my lord. The assets and liabilities of the petitioner is at annexure D1. That is page number 86, my lord. The petitioner has 2 dependents, my lord, other than the respondent 1 and 2. The 2 dependents are the children of his first marriage, my lord. In the first marriage, the first wife died due to medical ailment, my lord. Thereafter, the petitioner married the respondent number 1. After marrying the respondent number 1, the sole intent was that she would take care of the children of the first wife, my lord. However, thereafter in that marriage, they had another child who is the respondent number 2, my lord. In the meanwhile, my lord, the daughter of the first marriage, she was harassed to such an extent by the respondent number 1. She went and tried to commit suicide in Srirangpatna, where she was, the petitioner was thereafter intimated, and later on, when the petitioner was intimated with the same, he went and got back his daughter. She's been taking treatment before the Nimans, my lord. And thereafter, these are the two dependents that he has to take care of. And the respondent, after learning that the petitioner's first daughter tried to commit suicide, immediately she vacated the premises and fled from the premises in 2018 as claimed by her. However, the petitioner is claiming that she...
They're all not necessary. Come to the material of
Please,
the
my lord.
court. What is that? That's only we are
My lord,
only
the point of
concerned with
consideration that the
nothing
trial
else.
court has taken beyond the submission is that, my lord, page number 15, my lord, paragraph number 24. He has stated that he is working as a plumber. Page number 31, paragraph number 24, my lord. The respondent has produced his savings bank account from 2021 to 24, which is intermittently missing pages between months. In this affidavit of this assets and liabilities, he has stated that he is working as a plumber and earning rupees 20,000 per month. He is bearing expenses of rupees 40,000 to daughter and son born of first wife. And once he has paid 15,000 to the daughter born from the first petitioner, and is also managing loan accounts by renewing it, and obtained loan from e-Gopi. He is also getting financial help from the mother-in-law, that is the grandmother of the daughter and son born of the first wife. My lord, now going to my assets and liabilities, my lord. My lord, I have not even enclosed the fact that I'm spending 40,000 rupees per month with respect to the children, my lord. My expenses with respect to the children can be seen at page number 78, my lord.
20,000. How were you taking care of 4 children?
Please, two children from the first wife.
2 children from the second wife.
Second wife, there's only one child, my lord.
So 3 children. How are
Now
you
there are
taking
3 children, my lord. Now the mother-in-law of the first wife, she's also been assisting me in taking care of the first wife children. Financial aspect, my lord. She's assisting. The trial court has observed that also. In page number 32, my lord, he is also getting financial help from his mother-in-law, that is the grandmother of daughter and son born in
Paragraph
first.
number 24.
Please, my lord.
Yes, please.
My income is 20,000, my lord. Please, no. The respondent has produced his savings bank account statement from 2021 to 24, which is intermediately missing in between months. In his affidavit of assets and liabilities, he has stated that he is working as a plumber and earning rupees 20,000 per month. He is bearing expenses of 40,000 of daughter and son born of first wife. My lord, I am bearing only 20,000 as per my own affidavit. And the respondent is also not claiming that I am spending 40,000.
It's about your, that is your assertion.
Please, my lord, even they are not containing. The trial court, instead of considering 20,000 that I'm spending towards the first wife children, it has considered that for both of them I'm spending 20,000.
You pay, you take care of them for 20,000, then how will you survive?
My lord, for me, my lord, the issue is I am for survival purpose, I'm still borrowing. If your lordship may see, there are several loan accounts that I'm been paying. I'm been paying loan for almost 9.5 lakh rupees being a plumber. And I'm getting assistance from my first wife's mother, that is my mother-in-law.
Why you have not filed your complete bank statement?
My lord, now I have produced, my lord, at the time of filing of the objection.
What is the balance?
My lord, the balance in fact is 7 rupees, my lord. The bank statement, my lord, is from 1/4/2021 to.
Is filed before the court till what date?
My lord, apparently they have taken bank statements of from different periods and it's been attached.
Till which date you have filed before the court?
My lord, before the court it is from 2021 to 2024.
Let's see.
Please, my lord. Page number 125, Annexure G, my lord.
2024.
Is the starting, my lord. Page 125, Annexure G is the starting of my bank statement. Statement from 1/4/2021 to 31/12/2024. This is my entire bank statement, my lord. I was not able to produce a consolidated bank statement. Henceforth, now I'm producing before this honorable court, my lord. They are claiming that I am receiving almost a monthly income of 2 lakh rupees, which my entire bank statement hardly has any thousands also in it because I'm a daily wage worker.
Account you are having?
Please, ma'am.
Is it the only account you are having?
Please, my lord, this is the only account, and the same was furnished before the trial court. Only that,
So where from you get the money to spend for the children?
my lord, I'm a daily wage worker, my lord. I'm a plumber. So wherever I go for my work, I'm just paid my daily wages. So it is not like I'm.
Where from you got this 35,000?
My lord, 35,000 that last got is the amount that I've borrowed, my lord. I've borrowed and had taken a hand loan, my lord. I had borrowed that 35,000 and again paid back the 35,000. If your lordship may see, it is from, I had borrowed it from one Akshay, and then I had immediately.
Same day, 26/12, 26/12.
My lord, it's come in the in my assets and liabilities.
Why should you take money from somebody on 26/12 and you would give it back on the same day, 26/12?
I didn't give it to the same person, my lord. It was given to one E. Gopi, my lord. Even it's mentioned in the impugned order at page number 32 regarding my expenses.
No, whatever the statements that are made before the court doesn't inspire confidence in the mind of the court.
My lord.
You say you take care of 2 children.
Please, my lord.
And your parents.
No, not my parents.
So 2 children,
two children.
yourself.
Myself.
3 people, and the children have so many medical issues.
Please.
With this 20,000, you are able to do so many things. And even for borrowing of the amount also, only there is one entry. Nothing else. In the entire, only one entry.
My lord, there are gold loans that I have taken, my lord. Gold loans and banks from loans from the.
Earlier, there is a lot of, so many amounts are, coming and going from your account. Then thereafter, slowly that 80,000 is also there.
My lord, I have obtained gold loans at various intervals,
What
my
is
lord.
9/6/2023 entry? At page 174.
My lord, this is for what I've received from E. Gopi, my lord. If your lordship may see in the.
9/6/2023 is not Gopi.
My lord, it just says E, my lord.
What E? E means?
The E. Gopi, his full name is E. Gopi, my lord. It's there in the impugned order also, whereas it says that, and he is also managing loan accounts and renewing it and has obtained loan from E. Gopi. At times of immediate needs, if your lordship may see, I've got that.
Also.
My lord, if your lordship may see, my lord, that.
EXALSO, what is that?
My lord, that is at page.
26/5/2023. Page 172. In your pay 10,000.
My lord,
I'm not convinced with.
My lord, the very fact is that she has deserted me, my lord. She has deserted me in 2018.
That will be decided eventually.
My lord, she herself has stated, my lord, in 2018 she has deserted.
She has her own reasons, mostly.
She has deserted in 2018. The entire application or the petition before the family court does not indicate.
The court had granted 50,000 as maintenance. He is only earning 20,000. He has to take care of the 2 children from the first 5 and also take care of himself. And the court, without considering all this, has granted an amount of rupees 20,000 as 15,000 as maintenance. Considering the submission of the council, there shall be stay of all further proceeding on the condition that the petitioner shall pay an amount of rupees 8,000 to both the respondents, and by 5th of, and you shall pay by 5th of every succeeding month, and the arrears within 8 weeks, within 10 weeks at 8,000. Yes.
Notice.
Hand summons.
My lord, I may be permitted to serve on the council
Hand
before the
summons
trial.
on the council appearing for the respondent and shall file a memo to that effect. If the memo is not filed by 26th of September, the stay granted by this court stands vacated.
Cell number 19. Avinash.
Appearing for petitioner.
Lord, I'll take the notice, the respondent, my lord. I am filing the wakalat.
Then counsel so and so submits that he has instructions to file wakalat on behalf of the respondent. List this matter on 12th September. Next.
Serial number 20.
Look at it. Look at it, wherever there are interim orders, extend, whether they ask or not. It is represented. Is 20?
No,
Serial
sir,
number
for the
20.
petitioner. Annexure D, page 45 is the order not granting a visitation right to the father. Not, I am not principally agreed with this order. Mother is not principally agreed with this order. Now, difficulty is there is a reluctance by the child to go and meet the father. Reason is, not the 2020 father has abandoned the child. 2023.
Let's see, take out notice.
Not now execution petition is filed. He is seeking.
When was the order?
Not that was on order was on 23 2024.
Why are you questioning it now?
Not, I am not challenging now because now he has filed execution petition.
File execution, you should have brought it to the notice of the court. You should have filed an application for modification, and without doing it, coming before the
No, but
court.
there are mail correspondences, where mother has
It's not
made
right
a.
on the part of the court to, will not.
At least in the state of university, let them not precipitate the execution
But
proceedings.
why not? The petition shall take out hand summons on the counsel appearing for the respondent and shall
Any
file a
shortage.
memo to that effect. Once the memo is filed, list the matter.
Serial number 21.
For the petitioner in this matter, I've challenged the impugned order. Last date of hearing, court asked for the bank statement, my lords. Therefore, I'm just submitting the bank statement.
What is the amount that is
Challenge the impugned
granted?
order, which is at starts at page 12, and the reason is at page 20. The order is at page 22. The trial court has ordered 5,000 for the wife and 5,000 for the daughter. So the same I had challenged before this court.
What is your income?
My lords, I am a daily laborer, so I've just submitted that. So it depends, 300 I am earning in Madur. That is a daily income that I get. Sometimes I get.
So you will earn 15,000 per month.
Yes, my lords, I have a old aged mother. She is bedridden, and also I'm taking care of the treatment.
The petitioner is
And
daily
just
wage
one
laborer
submission, my
and
lords.
is earning around 15,000 per month. And the court had granted maintenance of 10,000 to both the wife and children, considering the same. They shall be stay of all further proceedings on the condition that the petitioner shall deposit an amount of rupees 6,000 per month by 5th of every succeeding month, and arrears also at 6,000 within 8 weeks. The same hand summons and memo also, like in the other case. Yes, next 22.
Grateful, my lords.
22.
I'm asking for the petitioner in this matter, my lords.
For the respondent, my lords, I undertake to file wakalat, my lords.
So and so submits that.
My lords, this is the fourth time that the petitioner is before this court challenging an order.
No, she is.
I'll undertake to file my wakalat.
But my
lords.
interim order will become infructuous if it's not passed today, my lords. If I may kindly take 2 minutes of your lordships. My lords, this is an IA.
We will hear it, and how many times he is coming to the court on that we will impose costs. Why just a
My
matter
lords,
of
but
court?
this honorable court has overruled the orders of the past by the trial court. In fact, the trial court continuously 3 times straight, and this is the 4th petition that I'm filing. Absolutely.
Impugned order.
Your lords may kindly have the impugned order at annexure A, my lords.
Page number.
Page 23, your lordships. My lords, all that I asked.
Let me
Yes, my
understand
lords.
first what
There
is
is
the order.
there is no separate wide order, my lords. In the order sheet itself.
Oh, where is it? Which
Page
date?
24 it starts, my lords. Annexure A.
Yes.
My lords, I would like your lordships to look through the order that has been passed, and the important sections of the order is at page 26, after the 6th para. It is also made clear that in the case of any holiday declared by the school for more than 4 days, that is for a week, the petitioner father is at liberty to have custody and visitation rights of 50 equal number of days, and he shall spend that time in Bangalore, and such an application or memo could be moved before the family court as and when such holiday arises, and the same shall be allowed by the family court. On the next page, my lords, at page 27, para 9, it says, to establish his contention that the minor child school has declared holidays on 23rd and 24, 26 and 27 of the August 2025, with only 25 August being working day in between, the respondent has not produced any supportive documents. Supportive documents are produced, and in fact, in the objections of the petitioner, who is the respondent here, and she admits about these holidays as well. My lords, in the Writ petition 27355 of 2024. The Honorable Court had granted me 50% overnight custody for me to take the child to Hyderabad during all longer vacations, which is summer, winter, Dasara and Diwali. In that, it also made an observation, whenever there is more than 4 days, I can just file a memo before the trial court and take my 50%. I filed one application before the Honorable Trial Court, that too after me asking the petitioner multiple times, and she did not agree to give me 1 day for celebrating Ganesh Chaturthi in Hyderabad. I filed an application telling that I would take the child has holidays, and the child has never spent any of these festivals with me, and always most of those festivals are celebrated with you, and therefore, and it's a big event in Hyderabad that the Ganesh Chaturthi happens, and the child has been repeatedly telling that it also wants to see it. I only asked for 2 days, my lords.
I think your clients of your and them, you should be made to pay additional court fees for coming to the courts like this. For every writ petition, at least for 50,000 to be paid to the Legal Services Authority.
Because
all the petty things, Hyderabad, I want to take
My lords,
Hyderabad.
what can I do, my lords? If your lords may kindly, my lords,
How
give
many
me
times you
one
will
moment,
come
my
to the
lords.
court?
I'll show your lordships one document, if I may. I'll serve the copy to the, my lords, one document.
No work, only fighting litigation, nothing else.
My lords,
For
I
one
asked.
day, half day.
I have repeatedly sent 3 back-to-back mails on at least 2 weeks before, my lords, requesting her that I'll take him to Hyderabad for 1 day.
Like the courts have no other work but to deal with only their life.
My lords, I don't have an option. The family court thinks that fathers are not worth taking care of their own children. I don't know, somehow that is what they reserved.
To be emotional because you also appear for the wife.
My lords, you won't
Advocate-
believe.
advocate can't afford to say.
It is so unfortunate.
Can't afford to make this kind of generalized
No,
statement.
my lords,
because you appear for both.
I will show your lordships. Your lords may kindly have.
No,
This
the
is an
statement
order.
You make now, I will remember it when you appear for the wife. I'll remember the statement when you appear
No,
the
my
other
lords.
side.
Here, but in
So,
this case,
you cannot
may
say
I,
that.
may I kindly, my
Because
lords,
it's just
let me,
nothing but wasting court's time with all
my
their
lords,
egos.
that is not the truth. All that I am telling
Come
is,
come up with your objections.
my lords, my interim prayer, my lords, kindly look into my
If the
interim.
court feels that there is something in your application, we will compensate those days on some other time.
Ganesh Chaturthi
No,
Visarjan
it's
that is
all.
happening this
Ganesh
weekend.
Visarjan, if he doesn't go to Hyderabad and see Ganesh Visarjan, nothing
It's
is going to
not-
happen. Let him be here in Bangalore and enjoy Bangalore. Yes. When will you come? When will you file your?
A short
when
date
will
may
you come?
kindly be accommodated.
My lords, next week someday.
Yes. This is the matter on 11th.
My lords, I have a small submission, my lords, to that effect. My lords, in
40 matters all. 17th.
My
yes.
lords, a small submission. This matter need not go for objections also, my lords. In WP 27355, Justice Pradeep has given a detailed order wherein all the festivals and all the vacations were clearly covered, my lords. Now, for one festival where the holiday is 1 day or 2 day, they come up with an application, my lords. And my lords,
To put a quietus to all that, I'll pass a detailed order.
Please, my lords.
So please come back with.
I will
whatever you
file my
want.
objections, my lords.
17.
Oblige, my lord.
Yes, 23.
Much
Admission
obliged.
matter, serial number 23. 23.
For the is your honor.
For the second respondent.
Yes.
For the appellate.
You're ready? Mr. Arafat.
I am ready, your honor.
Yes.
Lord, claimants
It's
appeal.
first is claimant's appeal.
Yes, Lord.
Second is
Second is insurance company appeal, my lord. On the
Maltesh.
ground.
For Maltesh is the claimant's appeal. Yes, first is the
This-
insurance. On what ground you are?
On
Lord, on the ground of the Lord, the disability.
PCR is not there. Is it required?
required because they have, insofar as the own damage claim, part of the claim is on 2 aspects. One, he was also the owner of the truck in which he was traveling. He wants certain compensation from my end because of the damage of the vehicle. He had made a claim against his own insurance company, a own damage claim, pursuant to which that was repudiated, pursuant to which he had filed a consumer complaint case. I am not aware of what happened to it, but whatever.
Admit, call for the TCR.
Also on negligence note, he has come into my path.
Serial number 24.
Yes.
24.
For enhancement, case of death, my lord. Give that. Accident occurred on.
It's already done calculation, 21,83,800.
Yes, my lord.
Will pass an order. What was the income considered by the court?
7,500, my lord.
So we have taken 9,000. Then
Future prospects.
prospects were not given.
Not given, my lord.
Then that deduction, that is one.
1/4 deduction, my lord.
Multiplier is correct.
Correct, my lord. 17 multiplier.
Yes. Agreed with the award passed in MVC number 514 of 2016 dated 4 February 2022. The claimant whereby the court had granted compensation of an amount of rupees 12,32,500. The claimant is before this court seeking enhancement of the compensation. Next para, the claim petition is filed seeking compensation of an amount of rupees how much?
25 lakhs, my lord.
25 lakhs for the injuries sustained by the claimant for the death of the deceased in the accident. The tribunal had granted the compensation as per the table given below. You will get the table at paragraph number 14. Then counsel appearing for the claimant submits that the court, this accident had taken place in the year
23/8/2015, my lord.
in the year 2015. Court ought to have taken 9,000, but the court had taken the income at 7,500 and failed to grant the future prospects. It is submitted that on all the counts, the compensation that is awarded by the tribunal is not just and reasonable. Then counsel appearing for the respondent insurance company submits that court has rightly granted the compensation considering the facts of the case and no enhancement is called for. Next para. Having heard the counsels on his side, peruse the material on record. Admittedly, this accident had taken place in the year 2015. As per the table, the income is 9,000. As he is aged about
30 years.
30 years, future prospects at 40% comes to 3,600. That is 12,600. How many are the claimants?
4.
4. As there are 4 claimants, 1/4 has to be deducted towards the personal expenses. 1/4 is 3,150 and his contribution to the family would be.
Sister. Therefore, 1/4 has rejected. Sister law. 5th respondent sister. Sister.
Though there are 5 respondents, 5th respondent is a sister. As such, 1/4 has to be deducted towards the first personal expenses. It comes to 3,150. His contribution to the family would be 9,450 into 12 into 17. Under the head of loss of dependency, they are entitled for an amount of rupees 19,27,800. 5 into 44 towards consortium, loss of consortium, 2,20,000. Funeral expenses 36,000. And legal in the light of the law laid down in Mekala versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 21,93,000. This is during the Lok Adalat time we have calculated.
Yes, ma'am.
93,000. Then why they didn't come forward?
Insurance company.
Or didn't come forward? And 21,93,800. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 12,32,500 to 21,93,800. The enhanced amount shall carry 6% interest. The appeal is partly allowed. Yes.
Cell number 25. Shashikant Prasad.
Yes.
Yes. Case of just 6-year-old boy. Last occasion, my friend has.
What do you say? The master Mallikarjun?
No, death case.
Oh, death case. That is Meena Devi.
Last occasion.
5.5 lakhs. 5.5 lakhs.
No. In this your honor, 8 lakh as awarded.
Tangavel and others.
Taken.
It has had some time.
Then what will happen to those judgments?
There is no ratio laid down on that.
5,000.
Me to the confusion that 5,40,000.
No, there is Purvan Ansari or what is it? First judgment.
Rajendra Singh case. Rajendra Singh case.
No.
Kishan Gopal.
Kishan Gopal. Thereafter, that is consistently followed in all the judgments.
27.
In this your honor, monthly income has taken 5,000. In para 6.
Whether those judgments are referred to in this. Kishan Gopal, it is a 2 judgments or 3 judgments? Take that, we have the judgment of Kishan Gopal. No, the high courts are left with a lot of confusion, what to do, what not to do.
One more judgment is that my lordship has referred on that. 2027 SEC 256 Rajendra Singh case. In that, instead of 30,000, 36,000 per annum has been considered.
They have referred to the judgment.
24.
Only for funeral expenses.
No, my lord, Pranay Sethi case has referred.
How is it concerned with Pranay Sethi in this?
For,
Kishan Gopal is only two judge bench, G.S. Singhvi and V. Gopal Gowda. What is the other judgment you are referring to?
My lord, Rajendra Singh versus National Insurance Company Limited.
That is?
That is, my lord, 2027 Supreme Court 256.
That is not there in our compilation.
2020.
2027 SEC.
Is it a two judge bench or a three judge bench? Rajendra.
See page.
Justice Gawai and Namit Singh. Two judges.
Two judges only.
But here, my lord, nothing has been discussed.
That's what earlier law is not discussed, nothing.
My lord, that clearly clarified on that.
Anyhow, if you want the same order, take a chance sometime. I'll not pass. If you want an order, I can pass basing on 5.5 lakhs at Meena Devi and other.
10-year-old, we are 6 years.
6 years old. Monthly income has taken 5,000.
There should be some consistency in the orders. Every day, like we can't apply something or the other like that. Consistently, we are following that.
I will consult my party.
Action. Then we'll have it on. What is the date?
17.
17th. We'll have it on 17th. Lalis's matter is parted on 17th.
Cell number 26.
Yes, Pradeep.
Pradeep B.
What about this?
My lord, I am for appellant in this case, my lord. It's a case of injury, my lord.
Respondent in 26.2.
Yes.
The disability considered by the tribunal is 51%.
Or on what ground?
Quantum.
51%.
Consider I am challenging that.
We'll see
Lord,
that. Which MVC is this?
MEC 185 is arising out of MFA 5221.
5221. No, there are only two appeals.
Two appeals. We have
only
only prepared two appeals, my lord.
What?
Two appeals,
26.2.
my lord.
3 appeals.
Total, my lord.
Okay.
Arising out of
So,
two MEC, my lord.
1 minute. MFA 5221 is arising out of?
5221, 185 of 21.
185.
Of
Then
20.
connected is next also 185.
Connect.
Then next
5209 is arising out of 183.
183.
183.
So let's go to the table of 185.
Please.
Page number?
Thing is that, my lord, the claimant appeal in 4171 of 23 in 185, they also prepared an appeal, but DD file Capula, it has shown that, my lord, it has been dismissed for non-compliance.
For non-compliance.
Yeah, we'll see this. MFA 4135 is pertaining to 185. So please,
Yes.
where is 185? The table of
4131.
42.
40?
42 onwards, my lord, there is a discussion. The table is that, my lord, internal page 27, my lord.
20?
27.
Before the discussion.
42 discussion, my lord. Internal page 27, my lord, there is a table.
I think it should be for the other case.
No, my lord, MEC 185 of 21.
1 minute. Issue now MBC number 182. The table is here. Is what you
No,
see that.
185, my lord. I'm first 185.
No, that I understand. You please come to this. Oh, next is MBC 183 is discussed.
183 is this.
Then where is 183?
183, my lord, 32 para.
Where is 185 discussed?
185, my lord, para 42.
No, Pradeep. So there is some confusion.
No, my lord.
No, the table which you are referring at page number 40, according to me, that is pertaining to MBC number 183.
183.
Para 40, my lord. Para 40.
Paragraph 32.
32. Yes, my lord. Paragraph 32, 183 of 21.
But we are dealing with 185.
No, my lord, it is 183. Para.
So I'm appearing for 183.
Huh?
Is that 26.2?
No, what about 5221?
5221, ಇಲ್ಲ, it says filed.
5221 is arising out of,
MEC 185 of 21.
right. So where is 185? That's what I'm looking at.
My
So if you
appeal is
see-
4131 of
No, wait,
21.
1 minute, Mr. Counsel. No, if you see, it starts at 32,183.
Yes.
Then the table, then please go through that. Then the table is at 40, paragraph.
Paragraph
number
40, right, my
But
lord?
there is only pertaining to 183.
Please, my lord.
We are looking for 185.
185, next para itself 185, my lord.
Where is the table for 185?
Table for
that is
27,
what
page
I'm
20,
asking.
page 27.
21.
So, let's go to
Sorry,
185.
27.
MFA 5221 of 23. So, what are the injuries?
Please, my lord. The fracture of left inferior pubic rami
Hmm.
and fracture of displaced sacral ala and fracture of third metatarsal, 3 fractures. my lord.
3 fractures.
Three fractures.
Court has granted 55.
55,000.
How much should be granted?
Our claimant appeal has dismissed. my lord.
Is that for non-prosecution, my lord? 4131, 4121.
My only grievance is that, my lord,
He has not even taken steps.
no, my lord, he has not filed review, recalling application.
You are not even asked for
Recalling
the-
application I have to file, my lord.
Then we'll hear it. Then both of you are here. Let him come up with the application.
Yes, my lord, I'll file application.
List this matter as part heard on 18th. On 18th.
My
This is
only
matter-
grievance is that, my lord, 10% disability,
So that
future
let
prospect.
his appeal also come, we will consider it.
Future prospect cannot be added.
No, give the next file. List this matter as part heard on 18th of September. By the time you file application on that day, we'll consider and pass orders in both.
Yes, ma'am.
Yes, now we'll take 26, 183.
My lord, along with that, my lordship, may
It's
common
a-
order has been passed there. On that day itself, my lordship may decide.
Both, all these 4 matters, list as part heard on 18th. Heard the councils in part, list the matter as part heard. Yes, 28.
Cell number 28. 27. Cell number 26.
27.
Lakshmi, for petitioner. Yes, Nagaraja.
Go for the respondent. Give that. Oh. Any urgency for you? This is the matter on 22nd September. Yes.
Cell number 28.
Here for the petitioner. In this
Jagdish.
case, we are challenging the quantum of the amount. Earlier, there was an order. I mean, permitted to place this order. It was,
How much is granted?
now it is 40,000 they have made, Mala. Earlier,
40,000 for 2 people,
2 children and wife,
for 3.
3.
What is your
Wow.
income?
Not, I am actually working as a laborer. My income is around 20,000. It may come, Mala. Little bit from the family sources also.
Let's see the.
Yes, my lord. In the judgment, it is not. Kindly, the another judgment, the earlier judgment, it was remanded back earlier.
Let's see this order first.
Yes, my lord. What they say is, since there are family properties, joint family properties,
How much, how many are the properties? What are the kind of properties?
agricultural lands,
What is the extent?
extent it is not been mentioned in the judgment, my lord.
Land
Extent
council
it
for
is
the
not been
petition.
mentioned. It is only on the guesswork that the court has,
Having 20,000, he's earning 20,000 per month, and the court had granted 40,000 as maintenance to the wife and 2 children, considering the submission of the council. There shall be stay or all further proceedings on the condition that he shall deposit 10,000 per month. 10,000 per month, by 10,000 per month by 5th of every succeeding month. Arrears also at 10,000 within 8 weeks. Issue emergent notice.
Cell number 29.
much obliged.
Respondent, they have not complied with the interim order, right?
We'll vacate the interim order first. And here file your execution. We'll vacate the interim order. Let them file you file your execution.
We were paying 1 lakh rupees as of now, Your Lordship. But then the difficulty
We
is,
are not concerned.
but then the difficulty is this, Your Lordship. There are two orders that have been passed for maintenance. One is under the DV Act, one is under section 125.
Here, what is the interim order?
9,000.
What is the order in the DV?
DV 9,000, Your Lordship.
Here,
Yeah, 15,000.
you are paying that?
That 9,000 only that we are paying in this particular proceedings, Your Lordship. Why? Because the 9,000 has reached finality by coming to the High Court. The petitioner was not represented in DV case. In only this case, we were handling the case and we have come before this honorable court. This matter can be disposed of today after hearing, because I'll take another 15-20 minutes, Your Lordship. Then this honorable court may decide.
No matter requires 15 minutes before this court. 5 minutes is more than enough.
For 5 minutes is more than enough.
You have to conclude in 5 minutes.
Yes. That is fine, Your Lordship.
Come to the order.
Your Lordship.
Come to the impugned order.
Come to the impugned. Annexure here, Your Lordship.
Yes.
This is the criminal petition wherein 15,000 was granted to the respondent herein. Annexure.
Where is impugned order?
Page number 10, Your Lordship. Criminal miscellaneous 538. Just 5 minutes, Your Lordship. Marriage was happened in the year 2012. In 2012, after 1 month of the marriage, the respondent was not residing with the petitioner herein. It is an admitted fact. Why? Because for 3 reasons, Your Lordship. If you
All
see.
those reasons are not at all concerned in deciding an RPS.
Yes.
You have to only tell the court about the maintenance of for 15,000 that is awarded by the court, how it is unreasonable.
Yes.
Why
Your
wife
Lordship.
is not entitled. All your relations and all, court is not concerned in a criminal.
Yes. No issues, Your
So,
Lordship.
what is your income?
As on today, ma'am, there is no income. He is unemployed, Your Lordship. From 6 months, he is unemployed. But then when he was working, his income was 40,000, Your Lordship.
This miscellaneous is filed in the year 2018.
2008. At that time, it was 40,000, Your Lordship. That is, as on today, he has got no income, Your Lordship. Your Lordship, the question is here, Your Lordship. In the year 2012, they filed the DV case. The DV case decreed for an amount of rupees 9,000.
When was it?
It was, again, it is in page number. In page annexure B, Your Lordship, in 38 June of 2014.
30?
I'll come to it, sir. In 2014, the order was passed. We appealed that order, stating we are not entitled to pay 9,000 on 3 grounds. One, the age was.
But these are not required. What happened to that?
The impugned order, again, in criminal appeal, Your Lordship, the DV case was dismissed. They came to the High Court. Again, everything I produced, Your Lordship. That is in page number.
So what happened finally?
Finally, the High Court has confirmed the order of the trial court of 9,000, which is in page number.
Pausing here.
Yes.
So from 2014
Yes.
till when is the order confirmed by this court?
This confirmed 6th January 2025, Your Lordship.
6 January 2025. What are the amounts that you have paid in the DVC proceedings of?
2 lakh rupees, Lordship.
Huh?
2 lakhs.
You have paid?
Yes. Why? Because, Your Lordship, why? Because in the year 2014, the
Anyhow, as of now, as far as the amount with regard to the, granted in Domestic Violence Act is concerned, you have paid. There are no
2
arrears.
lakhs. There are arrears.
How much?
There's 10 lakhs rupees, because the entire amount, if we calculate, is coming somewhat 11 to 12 lakhs, Your Lordship.
You have paid 10 lakhs.
2 lakhs. We have to pay 10 lakhs, Your Lordship.
12 lakh.
In DV case.
12 lakh 73,000. In that, they have paid only 2 lakh. They will have to pay 10 lakh 75,000.
Why? Because the order was passed only on.
He has paid substantial amount.
6th.
The meager amount to be paid.
No, Your Lordship. On 6th January 2025, the order was passed by the High Court. Why? Because the session court has dismissed their claim.
Oh, we'll see.
The session court has dismissed their claim, Your Lordship.
Court, when passing interim order, must have recorded all this.
9,000 per month.
1 minute. But, this court has not passed. Yes.
9,000 per month you have to pay. The interim order was granted, stating 9,000 per month you have to pay to the respondent, Your Lordship. The only condition here is they have taken 2 orders. What is over 15,000 and one was over 9,000. 9,000 has reached finality by this honorable court on 6th day of January 2025.
Also will reach finality by this order.
Yes, Your Lordship. The Rajneesh versus Neha judgment, Your Lordship. Everybody's unaware. Rajneesh versus Neha.
The judge, any order that is passed or any remedy that is available is in addition to the other remedies.
Your Lordship, that is the only reason.
Domestic Violence Act, that they are referring to the other domestic violence, the act itself says, notwithstanding.
Yes, but then the Honorable Supreme Court in page number 23, Your Lordship, directions on overlapping jurisdiction. It has very clearly stated, it is well stated that a wife can take a claim of maintenance under different statutes. For instance, there is no bar to seek maintenance between so and so and section 125 Code of Criminal Procedure or under HM Act. It could, however, be inequitable to direct the husband to pay
No,
maintenance
no, you please read it. 125
and 125 and DV Act. For instance, there is no bar to seek maintenance both under the DV Act and Section 125. They came seek maintenance. However, be inequitable to direct the husband to pay maintenance under each of the proceedings independent of the relief granted in the previous proceedings. If maintenance is awarded to the wife in a previous instituted proceedings, she has under the legal obligation to disclose the same in the subsequent proceedings. When they have come to the High Court, they have not disclosed this, that they have filed a that they have filed criminal miscellaneous petition before the family court.
We can't consider, we can't consider all this. Please tell the court about this 15,000, nothing else.
On 3 grounds, Your Lordship.
You have no, when you don't obey the order of the court, where the court had granted 9,000 to the wife, and conveniently from 2014 to 2025, you fought that litigation.
Yes, because
again you say that already she is having maintenance in that without even paying that maintenance.
No, Your Lordship, that reason is because in the year 2025, I got that the court came into a finality that I have to pay the maintenance. Before that, my case was admitted before the session court, and the order of the trial court was dismissed, Your Lordship. That is the reason I did not pay. In that January 2025, in the DV case, it came to a finality that I have to pay 9,000 maintenance under the DV Act. Again, they got order under Section 125. Under the DV Act, if you see the High Court order, not even a whisper is there that they have filed a criminal miscellaneous petition before the family court also for claiming maintenance. On 3 grounds, and the High Court has admitted that we have to pay 9,000 maintenance to the respondent.
So,
now this is my submission only this, Your Lordship, because we have not challenged the High Court order to the Supreme Court, we have to pay 9,000 to the respondent herein. The only thing is,
so because she's having an order in the domestic violence, this order needs to be set aside. That's
yes,
what is your
yes,
submission.
yes, Your Lordship.
Yes.
My
Yes,
submission
what
is
is-
that she is a heart patient. She is now suffering from autoimmune disorder also. She is struggling like anything right from 2012 onwards, but without paying any maintenance. She is struggling. She is depending upon her brother. That is a pathetic situation. So far as 2 orders are concerned, one under DV Act, they have
Forget
contested.
about that. It has nothing to do with this. Yes.
An interim order has to be necessarily vacated.
That's only one submission, Your Lordship. Why the maintenance order was dismissed by the trial session court was on 3 grounds. Because the marriage was made on the pretext. If you see just
Why
page
do
number
you
51.
rely on a ground on which that order is set aside by the High Court? You have to look at the High Court order, which has affirmed the.
Yes,
trial
9,000
court
it has.
order.
Yes.
So, it
That's
will not come to your rescue at all.
Yes, the only submission by
Yes.
relying on this judgment, Your Lordship, if you see the directions, they can take maintenance in one case and they cannot.
What are the medical expenses? What is the material filed before the court?
We have filed the assets and liabilities.
Mm.
We have filed.
In that you have stated what are the medical expenses?
No, yeah.
How much it is required?
We have sought for 40,000. Ultimately, court has granted only 9,000 in DV Act and 15,000 in the criminal case. Now, one order has become final because High Court has confirmed. So far, the order that has been passed under DV Act. Now that they are not challenging. Right from 2012 onwards, till this day, 13,75,000 is the due. They have paid only 2 lakh, even according to calculation of 9,000. 13,75,000 is the due. They have paid only 2 lakh.
Please come. Agreed with the orders passed to criminal miscellaneous number 538 of 2018 dated 30th December 2024, whereby the wife is granted that the husband is directed to pay maintenance of 15,000. The husband is before this court. The parties are residing separately from 2014.
2012. That is
2012.
Swami, there
parties
problem.
are residing
I just
separately.
make a small submission, Your
In the
Lordship.
year 2000, not necessary. Now, in the year 2014, the wife had sought maintenance under the Domestic Violence Act, and the court had granted maintenance of an amount of rupees 9,000. The husband has questioned the same by filing the criminal appeal, and the court and the appellate court had set aside the said order passed by the DVC court. Against that, the wife has come before this court, and this court had affirmed the order of granting 9,000 maintenance to the wife. Land counsel appearing for the affirmed. Land counsel appearing for the petitioner husband submits that the wife is not entitled to claim simultaneous maintenance under different acts. And when she files the application for maintenance in the already having maintenance in under the one act, while application in the other act, that has to be that fact has to be brought before the court. And according to the learned counsel, the said facts are not the wife had not clarified those aspects. This contention, that's what I'm recording, that is not clarified, that is not disclosed by the wife. It is submitted that now now he has to pay maintenance of 15,000 plus 9,000. That comes to 24,000. And the petitioner has lost his job and he is not in a position to pay the amount, and she is not entitled for. And this, while granting the interim order, the court had directed the husband to pay only 9,000. And as the order in the DV case has already attained finality, this order needs to be set aside, and he'll be paying an amount of rupees 9,000. Next paragraph. When counsel appearing for the respondent, wife submits that wife is suffering with autoimmune disease and also the heart ailment. She requires amount for her children are there.
No children, Your Lordship.
She requires money for her treatment.
They were residing only for 10 days, Your Lordship.
14 till now, the amount of 9,000 that is granted by the court, the amount comes to 12 lakhs and odd. 13 lakhs and odd. Until now, he has paid only rupees
2 lakhs.
2 lakhs. In spite of the wife passing through this kind of a critical health condition, the husband is not taking care of the wife, and he is not filing, he is not paying the amount to the wife. It is submitted that the submission that there is suppression of fact is without any basis, and they have disclosed the same. It is submitted that considering the health condition of the wife is the court had rightly considered and passed orders, and no interference is called for. Next.
And further, his salary is around 8,75,000. We have produced the income tax return.
It is submitted that even the income tax returns are placed before the court, showing that his year.
It is not there, Your Lordship.
59,000.
Adilla Swami.
Per year.
Per year, his income is 8 lakh.
8,79,000.
79,000.
And per month it becomes 75,000.
And
That has not been produced, Your Lordship.
And it is 8 lakh 75,000 per annum. Land counsel submits that considering the health condition of the wife, the order requires no interference. Next, for having got the counsels on either side, peruse the material on record. The DV proceedings were initiated in the year 2014, and in that the wife was granted 9,000.
2012, Your Lordship. DV proceedings were started 2012.
2012.
Came into finality
And in the year
2014.
2014, an order came to be passed, which was challenged both by the wife and the husband. Finally, it attained finality in the year 2025, where the order of granting maintenance of 9,000 is affirmed by this court. But admittedly, husband had paid a meager amount of 2 lakhs and odd, and 2 lakhs and odd. There is no dispute about the fact that the wife is suffering from autoimmune disease, and also she is having ailments to the heart, and she requires treatment.
Those medical documents have not been given to us, Your Lordship. It has not been produced, Your Lordship. And it is.
It said not admitted.
It has not been admitted.
Case of the respondent with regard to the health ailment. The court, it is the submission, this reliance on the judgment of the apex court versus Rashish versus Neha, and about non-disclosing the fact, considering the submission of the land counsel for the respondent, this court is not considering the same. In view of the health condition of the wife and a clear conduct on the part of the husband where, in spite of an order of the court, still not till now, he has not paid any amount. Even as per the interim order passed by this court, he has only paid part of the amount. This clearly shows that the husband has no respect to the orders of the court, and also no concern towards the wife who is suffering with health ailments. In these circumstances, this court do not find any reasons to interfere with the order passed by the tribunal. Accordingly, passed by the family court. accordingly dismissed. Yes,
Number
next.
30.
Your Lordship, but then contrary goes to Supreme Court, it clearly says in page number 91, they cannot claim maintenance of the two statutes, Your Lordships.
I've given a finding, now you, is for you to question it. There can be a maintenance. Yes. 30.
Number 30. Prashant Chandra is for petitioner.
Husband's petition requesting for reduction of the quantum of maintenance. I am in USA.
How much is granted?
45,000 is ordered per month. I am in
The
USA.
salary?
My salary is 5,25,000 in rupees and 45,000 is ordered. Wife, the respond is in Chikmagalur all alone. And 45,000 according to me is on the higher side.
Then we'll issue notice.
May I make two submissions. Why it is unreasonable? Earlier, this very court had ordered for 20,000 while appreciating the interim order. So 20,000 has been ordered. And now it is from 35, it has come to.
Salary of 5 lakh and odd, you cannot ask for any interim order. Notice to the respondent.
One submission. I am living with my parents, my child. She is all alone. I'm only on that. Whether in Chikmagalur place like Chikmagalur does it require 45,000?
That once it comes, we will decide.
May I make one more submission? The matter could be probably a matter for reunion. There are no other petitions. Keeping that in mind, may I request the court to grant interim order so that at least a reunion may happen in mediation.
If you want to go, once she comes, we will send to mediation. This is not a case to be interfered. We can't pass interim orders mechanically. Yes. Notice to the, emergent notice to the respondent. Yes.
Number 31. In B group.
May I request for a date?
Krishnamurthy.
Once
Because
the
there is
notice is
some
served,
execution is filed by them.
notice is served, it will come.
Execution is there.
Matter after notice is served. Execution is filed already.
Yes.
Petition is permitted to take out hand summons on the counsel appearing for the respondent and file a memo to that effect. Once the memo is filed, list the matter. Yes.
Cell number 51, 31. Gopal Krishnamurthy.
Huh?
The matter is settled, my lords. The mediation report, it may be disposed of.
It's already settled.
Please, my lords.
Give that.
Matter making to paternity test, it becomes infectious because the reunion happens.
As per the report placed before this court by the Director, Mediation Center, Chikmagalur, that the parties have appeared before the Mediation Center on 12/5/2025, 26/5/2025, 36/2025, 47/2025, 28/2025, and 16/8/2025. And a memorandum of settlement is filed. And it stated that the parties will be appearing before the court. Now, where is this? What is the settlement?
I got instruction from the client that the husband is ready.
Both of them have agreed to live together along with the son in that view of the matter. No further orders requires to be passed in this petition. Accordingly, the petition is disposed of in the light of the joint memo. Yes.
32 disposed, 32 urgent. Cell number 33.
Yes.
Notice is served to the respondent, my lord.
We'll hear it some other day. This is matter on, yes, next 34.
Cell number 34.
Date
24.
17/9. Cell number 34. Sunil S. Narayan.
For petitions. Yesterday I have deposited 50,000 rupees. Totally 1,20,000 until now. So 1,20,000 I have deposited 75,000 rupees until now. Balance is 45,000 rupees.
Whatever it is, you have to comply with the interim order.
I have paid 75,000 rupees. Balance from until today balance is 1,20,000. I have paid 75,000.
Another half is there.
No, not another 45,000 days.
Whatever it is.
I
interim order
will
has to
pay in the
stop
next
that.
state. I will pay in the next state. I will pay 22nd is the matter before the trial court. I will deposit another 45,000.
It is submitted that as per the orders of the court, whatever the arrears, he would be depositing by 22nd of September.
Yes.
If the amount is not deposited by 22nd, as per the interim order passed by this court, the stay granted by this court stands vacated.
Much.
Yes,
Till number 35 urgent,
this
36.
is matter on 25th. Yes.
Till number 35 urgent, 36.
This case as well for
Till
respondent.
number 36.
Yes.
Petition. With the wife's petition against the rejection of her application under section 24
On what ground?
on the ground that she has willfully deserted. The parameters of section 125 has been taken into account while dismissing an application under section 24. The parameters are different.
Which code is this?
But,
Well, let's see.
yes, yes. But, the reasons.
I think we can read from
Yes.
paragraph number 9.
Yes, Raish. The parties are residing separately from 24/11/2018 and their marriage on so and so. They have not even led the marital life for 4 months. The respondent is not having any children or wedlock. After a separation of all these years, the respondent has not claimed any maintenance from the petitioner. The petitioner has filed a memo, produced a copy of medical certificate evidence. The respondent in an earlier petition number 91/2019, a copy of the judgment. The respondent has earlier filed MC number so and so against the petitioner husband under section 12(1) so and so of the Marriage Act, declaration that the nullity of her marriage, and the said petition came to be dismissed as per the judgment dated so and so. The argument of the petitioner in the present case are prima facie facts. That case shows that after 3 months from the date of marriage, the respondent by wife had left the matrimonial home and deserted, kindly mark, the petitioner for these years. Therefore, the claim of the
Recently, we have filed a wakalat for respondent.
That's true. What we do is, please find out, please find what amount your client is ready to pay as interim maintenance. We'll dispose of and the MC will be decided. Please, what is the date to adjourn this matter? Which date to be given? 17/9. This is matter on 17/9. Yes, next.
Judgment cell number 37.
Respondent number 2.
Yes.
Appearing for respondent number 1, Your Lordship. In this matter, the Honorable Trial Court has gone through all documentary evidences and witnesses and held that there is no employer-employed relationship established between respondent number 1 and the deceased. And hence, the compensation was to be awarded, was to be paid by respondent number 2. If Your Lordship may please.
But he is submitting, his judgment is precisely on that. Though he is employed by the contractor, the accident had taken place in the premises of the employer. As per the act, principally the responsibility is on the employer, is what is the judgment is relying on. Okay. And what do you say about that judgment?
Your Lordship, according to in that judgment also, and we also have a judgment, and as per.
We'll do Ludo, look at it straight away. Yes. This judgment, which paragraph? What he is relying on?
Para 11 only, which they mentioned. Below that only, as per section 12, subsection 2, it is clearly mentioned that.
This judgment which you are relying on, of which court?
This is page number 2.
No, this judgment is of which court?
Judgment.
You're relying on Gujarat.
Gujarat.
Let's see this judgment.
In this, it is mentioned that as per the act.
You please read, let the court also read, then you make submissions.
Yes, Your Lordship.
Yes.
Para number 12, contracting.
That is what is extraction. Extraction, that is, the section is extracted there.
Yes. So, Your Lordship, para number 7, as per subsection 2 of section 12 of the Workmen Compensation Act, now employee compensation, when principal is liable to pay compensation under this section, he shall be entitled to be indemnified by the contractor.
Where are you reading?
Which? Para 7.
Para 7 starts with Advocate K. and Rajani. You're reading, I'm asking you to read the judgment of the Supreme Court. Not
Oh,
that.
this one, sorry,
Yes.
Your Lordship. Here. Para 11, they quoted, Your Lordship.
Hmm.
In that also, they've just extracted and
Read, you have to, when you want
okay.
to argue.
According to section 3, the liability to pay compensation is cast on an employer where an injury is caused to workman in an accident arising out of and in the course of his employment. The liability is absolute in as much as it is not necessary to prove negligence on the part of the employer. At the same time, the employer has no liability to compensate a workman who was at the relevant time under the influence of drinks or drugs, or who has willfully disobeyed an order given or rule expressly framed for the safety of the workman, or in cases where the workman has willfully removed a safety guard or other device provided for his safety. Section 12 makes the employer liable to pay compensation not only to his workmen but also to the workman employed by a contractor for the execution of his work. The above liability, however, is subject to his right to be indemnified by the contractor.
Correct.
So here, even if we have to pay,
No. On that, there is no dispute. He has no problem. He should have the problem.
I am for the contractor.
That's what. So, principally, he'll pay the amount and he will recover it from you.
That's all. That is only my argument.
that liberty can be maybe please given to us.
Will be given. Yes, please come. You are only on that ground.
It is only ground.
Only one.
Agreed with the order passed in ECA number 04 of 2018, dated 5th February 2020, whereby the tribunal had directed the contractor to pay the compensation to the claimant. The claimant is before this court. The claim petition is filed seeking compensation under section 22 of the Employees Compensation Act. It is a case of the claimant that deceased was employed by the respondent number 1. On 31/10/2017, the deceased worked the entire day in respondent number 1 estate on about 8 p.m. as per the direction of respondent number 1, while deceased repairing weed cutter machine under the lamplight. At that time, deceased caught fire to his body and got injured and succumbed to the same. The respondent number 1 denied the entire avowance. According to him, the deceased never worked with him. And in fact, is working under the second respondent contractor. And there is no employer-employee relationship between the first respondent and the claimant. The court, by order impugned, has observed that as per Exhibit P 6A to 6 reveals that deceased was employed by respondent number 2 and not under respondent number 1. Which clearly shows that there is no employer-employee relationship between the claimant and the first respondent, and accordingly granted compensation of an amount of rupees 8,28,800, which has to be paid by the contractor. Learned counsel for the appellant relied on the next para, relied on the judgment of the apex court in Secretary Kerala State Electricity Board versus MN Punjappa and others, reported in ACJ 20, ACJ second volume, page 2020. Here, relying on the said judgment, particularly paragraph number 11. Where is the finding?
Para 17, Your Lordship.
Advocate,
Hmm.
advocate for.
This paragraph number 11. Paragraph number 11 is only a argument. Paragraph number is an it is argument. Where is the finding? So without any paragraph, he has relied on the judgment in so and so, and submits that even if he is engaged by the contractor as per section 12 of the Act, 12 of the Workmen Compensation Act, it is the employer in whose premises the accident had taken place is liable to pay the compensation, and he can recover it from the contractor. Land counsel for the appellant claimant submits that the court had failed to consider all these aspects and had granted fixed the liability on the contractor. Land counsel appearing for the respondent employer and also the contractor supports the case, supports the order impugned and submits that no interference is called for. Next, having heard the counsels on either side, there is the material on record. The undisputed facts in this case are the deceased was engaged by the engaged with the second respondent to work in the first respondent estate. Accident had happened while he was working in the first respondent estate. In view of section 12, the initial burden to pay the compensation lies on the employer in whose premises the accident has happened. And later, the contract, you can seek you can recover the same from the contractor. In the light of the clear language employed in section 12 of the Act, the respondent number 1 is liable to pay the compensation and recover the same from the owner from the contractor. Accordingly, the appeal is allowed appeal is partly allowed, and the order of the court as far as the payment of compensation on the second respondent is modified, and the first respondent is liable to pay and recover the same from the second respondent.
Yes.
Yes.
For finally,
Yes.
Tell number 38.
Responding.
Huh? What about 38.1? Non-furnished. Huh?
R2 is the one who filed the connected appeal.
No. Who is R2?
R2, my lord, is the insurance company. Who is an appeal in
Ashok and Patil.
Yes.
Wakalat not filed. Memo receipt of having paid the cost of rupees 1,000 filed by Ashok advocate returned with office objection. You represent Ashok and Patil.
Yes, ma'am. I represent. There are the 2 appeals filed by the
insurance companies on what ground?
This is the appeal filed by us challenging the liability, my lord. We are specifically disputing the involvement of the insured vehicle in the alleged accident. My lord, what happened, my lord, on 7/11?
We'll have this some other day.
These
2 matters. Give a date. Yes, next 39.
Cell number 39, 17, 9, 38, 79, 39.
Who appears for the respondent in this?
Claimant respondent, my lord.
No, in 39.1.
39.1 of
Vijay Kumar T.
Vijay Kumar T.
Here. Then what about the respondent?
Respondent
You have to serve notice.
39.1 kindly direct the Bano Prakash HV.
So how many are the respondents? Ban Prakash HV.
Only one sole
Mr.
respondent.
Ban Prakash HV is directed to take notice on behalf of the respondents in 39.1. Then counsels for the appellant shall serve the appeal memo. This also give a date. Yes, 40.
17, 9.
Yes.
Cell number 40.
17, please.
Yes, 40.
40. Girish B. Baldare.
Let's requesting a week time to file an judgment.
This is a matter on 24th.
22, 9.
Yes, 41.
41.
Appellate is connected, sir. 41 for 1 and I am from the appellate. Connected case.
Yes, this also give a date.
22, 9.
Yes, 42.
Cell number 42. Pradeep B.
For the respondent, your lordship.
Yes, Pradeep, what is this?
But involvement of the vehicle is questioned.
This also give a date on 17th or 18th, whenever it is.
17/9.
Yes.
Cell number 43.
What about this?
Yes, the lordship. In the matter 42, your lordship. It's been more than 7 years, your lordship.
No, we'll decide it this week.
17/9.
This week only it is given.
How this?
I mean, this month only it is given.
Yes, sir.
We'll hear it.
Yes, your lordship.
Yes,
Kindly
43.
top up the list, your lordship. On the top of the list.
No, without, we will complete it, don't worry. Yes, 43?
33 Millard.
I appear for
Only I am challenging quantum.
Then we will decide if it is
apportionment
quantum.
only, my lord. Please.
Yes.
My lord, serial number 2.
Oh,
my
there
lord,
are
which
43.2. Two advocates are,
Millard, this one
Total
MEC
three.
cases, Millard.
Huh?
Only one MEC case, Millard.
Uh.
I have preferred an appeal on the ground of quantum. They have disputing the apportionment made by the tribunal.
You are appealing for whom?
Parents
Not
and-
only disputing
and
apportionment.
seeking enhancement.
I am for asking enhancement.
Enhancement.
Another appeal is by the wife.
I appear for the wife,
Though
my
she cooperated in
Then,
the,
this also
cooperated in the.
this also give a date.
Then no, there is no dispute with regard to the
quantum.
Apportionment only, my lord.
apportionment.
Apportionment also no dispute.
No dispute.
Apportionment, we have raised appeal, my lord. We prefer to appeal, my lord.
Whatever amount she is entitled, let her get.
Cell number 44.
Yes, you will give a date.
22.
40
Month, short date.
44 also.
Please.
44 also.
22/9.
Much obliged,
Cell
my
number
lord.
45.
Manoj,
30
45, I appear for the respondent, Manoj.
Yes.
And the connected Manoj, I am the petitioner.
Give a date. On this, not on same day, some other day you give.
Yes, sir. 15/9.
Yes.
Grateful.
My lord, passed over matter, my lord, serial number 2.
Where is he?
My lord.
Serial will be here after if
He'll be keep on coming. From that time he's arguing before one court. Which court is arguing?
Millard, she was arguing before RERA. He's on the way.
RERA is important or High Court? RERA is above High Court.
No, Millard, the RERA, it was last to final.
This is
hearing.
matter tomorrow, on the Monday. How many matters are there?
Monday.
Monday. Then what about the other matter also, that Pradeep, 3 matters, that also can be on Monday? That MFS, 3 MFS are there.
8 minutes.
Working.
Are there. So this matter, post it as part heard on Tuesday.
Please, my lord.
Tuesday. Cell number 2.